Court officer? Court officer? ಇಲ್ಲ
ಹೇಳಿ ಮೇಡಮ್.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಅದನ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಳ್ಳೋಕ್ಕೋಸ್ಕರ ಮಾಡಿದ್ದೇನೆ. ಥ್ಯಾಂಕ್ ಯು.
ಕೇಳಿಸುತ್ತೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ವಿತೌಟ್ ಯೂನಿಫಾರ್ಮ್ ಎಲ್ಲ ಕನೆಕ್ಟ್ ಆಗ್ತಾರೆ. ಯಾರು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್? ಮೇಡಮ್ ಏನ್ ಬೇಕು ಹೇಳಿ ನಿಮ್ಗೆ?
ಏನಿಲ್ಲ, ಜಸ್ಟ್ ಗೆಟ್ ಮೈ ಸೆಲ್ಫ್ ಕನ್ಫರ್ಮ್ಡ್.
ಅಲ್ಲ, ಇವ್ರು ಯಾರೋ ಇನ್ನೊಬ್ರು ಲೇಡಿ ಕನೆಕ್ಟ್ ಆಗಿದ್ದಾರೆ.
ಕೇಳಿ 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 ಕೇಳಿ.
ಏನ್ ಬೇಕು ಮೇಡಮ್? ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್. ಏನು ಕೇಳಿಸಲ್ಲ ಇವ್ರದ್ದು. ಹ್ಯಾಂಡ್ ರೈಸ್ ರಿಕ್ವೆಸ್ಟ್ ಅಂತೆ. ಅದೇನದು ಆಪ್ಷನ್ ಕೊಟ್ಟ ಇಲ್ಲ. ಹ್ಯಾಂಡ್ ರೈಟ್ ರಿಕ್ವೆಸ್ಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡೋದು. ಸರ್, ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಎಲ್ಲ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು. ಯು ಆರ್ ಎ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್, ಯು ಹ್ಯಾವ್ ಟು ಮೂವ್ ಇಟ್. ಅಲ್ಲೆಲ್ಲ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಕು ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಗೆ. ಹೌದು, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀರಾ? ಅದು ನೋಡ್ಬೇಕು. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ. ಬ್ರಾಂಚ್ ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ ಇದೆ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಆದ್ರೆ ಇಮಿಡಿಯೇಟ್ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ.
ಮೇಡಮ್ ಅವರೇ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್
ಕಂಪ್ಲೈಂಟ್ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿ.
ಮೆಮೊ ಕೊಡಬಹುದಾ
ಸರ್? ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ಸ್ ಇದೆ ಸರ್.
ಏನಂತೆ ಏನಂತೆ?
ನೀವು ಆಲ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈಂಟ್ ಇಟ್ ಶುಡ್ ಬಿ ಪೋಸ್ಟೆಡ್ ಅಂತ ನೀವು ಅವ್ರನ್ನ ಕೇಳಿದ್ರೆ ಎಲ್ಲ ರಿಜಿಸ್ಟರ್ ಒಂದು ಪೆಂಡೆನ್ಸಿನೇ ಇರುವಂತೆ ಜಿಎಂಎಫ್ಸಿ ಎಲ್ಲರೂ ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಇರುತ್ತೆ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಪೋಸ್ಟ್ ಮಾಡೋದಿಲ್ಲ.
ನಮ್ದು ಸ್ಟೇ ವೆಕೇಟಿಂಗ್ ಇದೆ ಮೇಡಮ್.
ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರು ಪೋಸ್ಟ್ ಮಾಡೋದಿಲ್ಲ. ಈವನ್ ಇಫ್ ಯು ಮೂವ್ ಮೆಮೊ ಆಲ್ಸೋ ಅಂಡ್ ಸಬ್ಮಿಷನ್ ಇದ್ರು ಮೂವ್ ಮಾಡೋದಿಲ್ಲ.
ಇದು ಕಂಡೀಷನ್.
ಟೈಮ್ ಆಗೋಗಿದೆ, ಅದು ಕೊಡ್ತಾರೆ ಮೇಡಮ್ ಟ್ರೈನಿಂಗ್ ಅಲ್ಲಿ. ಅದು ಟೈಮ್ ಆಗೋಗಿದೆ. 2 ವೀಕ್ಸ್ ಕಂಪ್ಲೇಂಟ್ಸ್ 2 ವೀಕ್ಸ್ ಟೈಮ್ ಆಗೋಗಿದೆ. ಅದ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದ್ರೆ ಫೈಲ್ ಕೊಡ್ತಾರೆ, ಇವಾಗ ಕೊಡಲ್ಲ ಮೇಡಮ್.
ಒಂದು ಪೆಂಡೆನ್ಸ್ ಇಲ್ಲ ಜಿಎಂಎಫ್ಸಿ ಸ್ಕೂಟ್ನಿ ಅಂತಾರೆ. ಇವ್ರು ನೋಡಿದ್ರೆ ಅವ್ರು ಸ್ಕೂಟ್ನಿ ಮಾಡಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಬಂದು ಈ ತರ ಕಂಪ್ಲೇಂಟ್. ಅವರು ಸ್ಕೂಟ್ನಿ ಮಾಡಿದ್ದಾರೆ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಇದೆ ಅಂತೆಲ್ಲ. ಅದು ನಮ್ಮ ಮುಂದೆ ಪೋಸ್ಟ್ ಮಾಡಂಗಿಲ್ವಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಇದ್ರೆ. ಡೈರೆಕ್ಷನ್ಸ್ ಇವ್ರು ಹೋಗಿ ಅಲ್ಲಿ ಫೈಲ್ ಏನಾಗಿದೆ ಸ್ಕೂಟ್ನಿ ಮಾಡಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿ ಕಳಿಸಿ ಬೋರ್ಡ್ಗೆ ಅಂತ ಕಳಿಸ್ತಾರೆ ಅವರು.
Hello, madam. Madam, can you hear me? Excuse me, madam. Excuse me, madam, can you hear me?
ಸುಮ್ಮನೆ ಅದೇ ಮೇಡಮ್ ಮೆಮೋ ಹೇಳಿ ನಿಮ್ದೆಲ್ಲ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅಂತ ನಾವು ಹಂಗೆ ತಗೊಳಕ್ ಹೋಗಲ್ಲ.
Make one submission, my lord. See, this matter is already given direction to trial court, dispose the matter within 4 months, my lord. See, I am challenging the IA, my lord, 24 application. Matter is not listed, my lord, I have it on Monday. As an emergency.
When is that IA order is passed?
My lord, without, I am the respondent before the trial court, last 3 weeks back, my lord.
Yes.
Monday.
Fresh matter, no memos are required. Fresh matters will come provided office objections are complied with.
The office objections are all complied. It is filed on 6/8, but till today it is not posted.
Find out why it is not happening.
They are asking me file a memo, otherwise it is not easy.
Ask.
Yesterday only they asked.
As soon as the office application is ready, 4 days after lapse of 4 days, they will send up for posting report. Such files they are asking for compliance. It is not possible.
Everybody is saying that when you verify it, it says office objections are not complied with.
Complied.
Give it. If it is compliant, and tell her, take that memo, ask the court officer why it is not coming, she'll tell.
My lordship, I have one memo for posting in a disposed case where I would like to submit for recall of the order only related to visitation, because my previous counsel, despite giving clear instructions, they somehow missed asking for more visitation, my lord, and it has materially prejudiced because my son is asking me, why are you not coming like before? And I don't have an answer, my
Take
lord.
it. Yes.
Kindly, my lord, memo for being spoken to.
Next
One
week,
clerical order, that the date is to be rectified. Date is to be
Oh.
rectified.
Yes.
My lords, memo for posting for, it's a 2023 matter, my lords, to the release of deposit money, my lords, it's 2023.
All these matters will come as per basing on the convenience of the court in the next 1 week.
It's a 2023, man.
That's what I'm saying. Next 1 week, they will list somewhere, they will list the matters. Yes, call the
My
list.
lord, this is a matter of a visitation. The petition respondent is not granting to meet the child to the petitioner. It's a minor son. The trial court has granted the interim
Take
custody.
this. Please, whatever the memos that are given, basing on our list, please do that, like particular dates are given. And also verify that whether all of them are posted or not. And when you tell me what are the memos pending for posting every day. Yes,
The interim application filed by the petitioner, wife, my lord, rejected in trial court. Now she is in financial crisis.
when was it rejected?
Lord, 23/7/2025.
Suddenly 25, you realize the financial constraint. We will list it as per the convenience. Yes. Call the list.
Page wise adjournment. List 1, page number 2, serial number 5.
My lord, one mentioning, my lord.
Yes.
My lord, serial number, list number 2, serial number 10, my lord.
Yes.
I
With
appear for
regard to
petitioner in this
settlement.
matter, my lords, serial number 10. The matter is settled. The affidavit is being filed, my lords. It may be taken up next week. Both the parties will appear and will resolve this, my lords.
Which list she is referring to?
List 2, serial number 10, my lords.
That will be called, all those matters will be called. Out
Please,
of the
please.
list mentions only you have to make. Yes.
Page wise adjournment. List number 1, page number 2, serial number 5, 6, page number 3, 7 to 9, page number 4, 10 to 12, page number 5, 13 to 16, page number 6, 17, page number 7, 18.
My lord, 18, serial number 18. I'm praying for time, my lord. It is a insurance company's appeal. deposition and the exhibits are in Kannada. I've already given the file to the insurance company. The translation are going on. Kindly.
Have you informed the other side? It can be adjourned. But we'll give a long date because completely September, there are so many matters every day. If anybody is asking at the risk of longer adjournment, they're asking. This is the matter on 25th of November at the request of counsel the appellant. Yes.
Page number 8, serial number 1920, list number.
This is doctor. Yes.
List number 2, page number 1, page number 2, serial number 4, 5, page number 3, serial number 6 to 7, page number 4, serial number 8 to 17.
Milords, serial number 10, Milords.
Yes.
Appear for petition in this matter,
Yes.
Milords.
When you
Respondent
want it,
counsel is
when it can be taken up.
next Thursday or Friday, Milords.
Yes, give the date on Thursday. List the matter on Thursday. Yes, next.
Grateful, Milords. Grateful.
Page number 5, serial number 18, list number 3, page 1, serial number 1 to 3, page 2, serial number 4 to 6, page 3, serial number 7 to 10, list number 4, referring to Lok Adalat.
All these matters, list 4 is referred to the Lok Adalat.
One submission, my lord. One submission, my lord. Serial number 65. The petition has been dismissed and filed by the adjudicator. Therefore, this cannot go to Lok Adalat. 65.
I appear for petitioner in this case, appellant in this case.
Date may be assigned sometime next week so that it may be taken up for admission.
Please, my lord.
61, sir.
65.
65.
Yes. Yes.
65, my lord.
Delete from the list, post in the usual course. Any
Serial-
other matters?
Serial number 66, my lords. Claim petition came to be dismissed.
Yes, this also delete.
73 also.
70?
66.
73. Yes, delete. Yes.
58.
Also should be deleted.
66, huh?
Yes, 58 delete. Yes, so remaining list. All remaining list to be referred. Yes.
List number 5, serial number 1 and 2, page
Yes.
1, list number 1, contact matter, Padmanabha Kedilaya for appellant,
Where is Pradeep?
P. Pradeep.
Yes. What is this matter about? Give the order sheet.
My lord, last occasion, my lord.
Last occasion, what happened? Heard
trailer-
Hotel and councils in part, list the matter on 20th.
trailer
We're
is
here.
not-
Yes.
The trailer is not insured with us, my lord. The tractor loan is insured with the company.
Some
They are
judgment she was
traveling,
referring to.
They relied upon the apex court judgment that, my lord, in that pain recovery order has been passed. Before that, my lord, the apex court has held that, my lord, the trailer and trailer both should be insured together. That judgment also referred on
Which,
that.
which year is that? Was it considered in that judgment?
Yes, my lord.
Then it has to be taken into
Para 8,
consideration.
my lord, has been considered.
We'll follow that.
Please,
Pass on. You already passed on?
please, my lord. It is there.
Look at
in the
it,
file,
look
my
in the
lord.
file. If you have a copy, please give the copy. No, she says, last time she has given the judgment.
No, she has given one judgment of.
Is this Royal Sundaram Alliance versus Honamma?
Yes, my lord. That's it.
Please, my lord.
Which paragraph?
Para 13, my lord.
Also same copy like this?
No, my lord. Please.
It is the paragraphs and all very confusing it is.
Para 8,
This-
my lord, the judgment has been referred. In para 13, there is a conclusion. 147, the tractor cannot be moved. Trailer attached to the trailer. On that basis, my lord.
We have to see para 4, 8.
Para 8, my lord, which I am relying upon that that judgment has been referred on that.
One
Then to
minute,
buy.
one minute. Appellant submissions, analysis, reasoning and conclusion starts at 9.
Para 8, my lord, the judgment has been extracted.
Lastly, Lenin Council relied on the judgment. New India Company Limited versus M. Jaya, 2002, 2 SCC. Compensation could not exceed the limits of the insurance policy. And on Dandubai versus Hanumanthappa
Dandubai.
Pandappa. This is the one you're
This is
relying.
the
The second
Dandubai
one.
judgment, the apex.
Give that.
In that, my lord, the 142 has been extracted. My lord, invoke 142 and the order.
Pay and recover is what.
That, but it is not applicable to all the.
But they said that it has to be insured. In this,
Please.
this also half-page judgment. Para 11 appears to be the correct reasoning. Para 11 of the, you don't have the copy?
No.
Give him the copy. You have?
Yes.
Look at para 11.
Para 13, my lord.
Therefore, the undisputed position of is that the trailer was being pulled by attached to the tractor, and then the trailer which the deceased was present turned total upset, resulting in his death. From the above, it is clear that the tractor which was insured was the reason for the accident. It is not the case only because of some fault of the part of the trailer stand alone. The accident happened. To explain, we may give example that the trailer being stationary at the place of due to some reason, it overruled or mishap happened, then without the trailer being specified, insured, the appellant would not be liable to pay. But here the main cause for the accident.
If you remember, earlier also you have condemned it. This was my view. And you were, insurance companies were relying on this.
Please.
This is a correct law. And look at 14, where how it is distinguished also.
Please, Dandubai case did not.
To our mind, did not lay an absolute.
To our mind, the learned judges in Dandubai did not lay down the absolute principle of law, but taking note Oriental Insurance Company Brijmohan, and
then they have relied on the Andhra Pradesh High Court judgment.
Please. But the registration is different, my lord. The tractor and trailer, both should be registered separately.
As per this.
Separately. And both should be insured together separately.
No, para 13.
Para 13.
They say that that's the correct law.
Analysis, I saw that, my lord. Analysis, I saw that. Without tractor, trailer cannot be moved. That analysis.
That's a simple thing. Registration for trailer is altogether for a different purpose. For a motor accident, it is not moving on its own.
Here,
the
my
vehicle
lord,
which is having the insurance is.
If he is third party to the vehicle, my lord, then the principal are laid down by the apex.
No, here he is a third party. He is not the insured. The person who
is the employer. Here also same. In that case also employer, but employee not.
No. If it is insured, if he is insured, then it is a different aspect. It is a third party.
What my thought is, my lord, if the tractor hit some other vehicle, they become a third party, my lord, then they are entitled to compensation. But here, my lord, the employee being carrying the vehicle.
So even even the coolies and all are covered. Though they need not be employees.
Actually, my lord, in the tractor, my lord, except driver, no person should carry on
Trailer, they are in the trailer.
Uninsured trailer, my lord. That's what, my lord.
They are in the trailer. But how that is a trailer moving on its own?
My lord, the apex court has given reasoning. I cannot comment upon that.
But anyhow, it is good for the claimants. Please come. So what about the other thing?
Lord,
liability is fixed on the
owner
of the vehicle. That is one aspect. Then about calculation.
Calculation, my lord, loss of dependency, my lord.
Come to the that
Number 14, my lord.
Is there any that table?
Please, my lord.
Table at which
Table
page?
at
Page number
internal page 9.
9 of the judgment, my lord.
Page 9.
Page 9.
So what is the age?
Date, my lord, 14, my lord.
Huh?
21 years. Age. 21 years.
21 years.
21 years.
Which year is the accident?
2014, my lord. 16/5/2014.
2014. Court has taken the income at?
Income 7,500.
9,500.
As per the table?
9,000 is to be.
No, 8,500.
8,500 is to be taken.
8,000?
500.
Multiplier?
18 million.
Rightly applied?
Rightly applied.
Future prospects considered?
40%.
40%.
Considered?
Considered 40%.
So, unmarried?
Please, my lord.
Half has been paid.
7,500. 8,500. 40% is? 3,400. 5 plus 4, 9. 11,900.
12,85,200.
5,950 into 12 into 18.
12,85,200.
12,85,200 towards loss of dependence.
Consortium.
Payments or parents?
No, my lord. Only one
Payments or
dependent.
parents?
Please,
Only one dependent.
only one.
One dependent. Only one. Mother alone dependent.
Mother, only mother, my lord.
Then loss of consortium?
Consortium.
40 years awarded.
44,000. You said 40?
40 years awarded.
44,000, 36,000 and 10,000. Less 44,000, 36,000 plus 10,000. It comes to 13,75,200 against 12,04,000. Please come. Agreed with the award passed in MBC number 49 of 2015, dated. This 2 o'clock matter is there, no? That in chamber matter. That I said I will take it up at 5 o'clock. Please inform the advocates. I told Suvarna, whether informed or not, please ask. Otherwise, again, they will come no by 2 o'clock. We'll take it up at 5 o'clock. Agreed with the award passed in MBC number 49 of 2015, dated 10th August 2018. The claimant is before this court, before this court, seeking enhancement of the compensation and also questioning the liability fixed on the owner of the vehicle. The claim petition is filed, granting compensation of an amount of rupees 17 lakhs 30,000. The case of the claimant is that the son of the claimant was loading a firewood to the tractor trailer on 16/5/2014, and after loading firewood was traveling in the said trailer, and because of the rash and negligent driving of the driver of the vehicle, it fell into a ditch. Due to the said accident, the deceased fell on the ground, and the firewood loaded in the trailer fell on him, causing grievous injuries to him, resulting in his death. The court had fixed the liability on the owner of the vehicle. On the driver of the vehicle. That's what, the driver and owner of the vehicle. The reason given by the court for fixing the liability on the owner of the vehicle, and owner and the driver, is that only the tractor is insured, but not the trailer. And undisputedly, the deceased was traveling in the trailer, sitting on the firewood at the time of the accident. Hence, it's the owner and the driver alone liable to pay the compensation. Then when it comes to the compensation, the court had considered the income at 7,500 and granted compensation of an amount of rupees 12,04,000. Next paragraph. Learned counsel appearing for the appellant claimant submits that the court went wrong in fixing the liability on the owner of the vehicle. She submits that even though the tractor is not insured, still the insurance company is liable to pay the compensation. She relied on the judgment of the latest judgment of the apex court in Royal Sundaram Alliance Insurance Company Limited versus Srimati Honnamma and others. Dated, what is the date of the order? May 5th, 2025, wherein the Honorable Apex Court, in the similar set of circumstances, facts and circumstances, where the trailer was not insured, but the tractor was insured, had held that the insurance company is liable to pay the compensation. It is submitted that in the light of the said law, the insurance company has to pay the compensation. It is coming to the compensation. It is submitted that the court, as per the table, as this accident has taken place in the year 2015, court ought to have taken 8,500. 2014, that's what. 2014, court ought to have taken the income at 8,500. Next paragraph. Learned counsel appearing for the insurance company submits that, in fact, the Honorable Apex Court in Hanmantappa Bandappa Andegude versus party's name also is not clear, no? Correct. Dondubai versus Hanmantappa Bandappa Gandigode and others. Relying on this judgment, Learned counsel submits that in this judgment, exercising, though it is held that the tractor needs to be insured, however, exercising the power under 142, court had applied the principle of pay and recover. He submits that in the light of the judgment of the apex court and thus, which clearly shows that the registration of the trailer is also necessary for imposing the liability on the insurance company. In response to that, learned counsel appearing for the petitioner submits that, in fact, this judgment of the apex court in Dondubai is considered in Royal Sundaram Alliance Insurance Deferred Sutra and submits that this judgment applies to the facts of the present case. Next part. Having other counsels on either side, there is the material on record. Coming to the liability, the facts are that the deceased was traveling as he was a coolie loading after loading the firewood. He was sitting on the firewood and traveling in the trailer, and admittedly trailer was not insured, but the tractor was insured. According to the learned counsel in that judgment just now I said, insurance company, unless the trailer is insured, the insurance company is not liable. This court has perused the judgment that is relied on by the learned counsel for the appellant in Royal Sundaram Alliance Insurance Company case, and it is appropriate to look at para 12. I'll just mark it from here. 11, 12, whatever that is marked, extracted. So and so. In the light of the said judgment, it is clear that though the trailer is not insured, still the insurance company is liable to pay the compensation. Hence, the liability is on the insurance company. Then coming to the quantum, this accident had taken place in the year 2014, taking the notional income at 8,500 and considering the age of 21 years, future prospect at 40% comes to 3,400. Then his salary is 11,000, his income is 11,900. As he is a bachelor, 50% has to be deducted. It comes to 5,950. And the hence into 12 into 15 is 12,85,200 under the head of loss of dependency. Coming to the loss of consortium, claimant is the mother, 44,000, funeral expenses 36,000, and in the light of the law laid down in Mekala versus so and so, 10,000 towards the legal expenses. Altogether, the claimant is entitled for an amount of rupees 13,75,200. Accordingly, the appeal is partly allowed, enhancing the compensation from so and so to so and so. The insurance company is liable to pay the compensation, and the on the amount the interest is at 6%. Yes, next. Huh?
Recover the same from the owner.
Did you say so?
Yes, ma'am. When recovery order.
In this case, it is not there. Let's see. Where it says?
Last.
Which para? On what basis pay and recover will apply in this case? When once you say that it need not be insured, then where is the violation of the conditions or what? Only on that conditions pay and recover will apply.
Same owner may not was to the uninsured trailer. That's what last
Paragraph?
19.
Huh?
Para 19. Before that, what emerges to the applied not to saddle the payment of compensation.
Infirmity and impugned order, either with regard to the quantum of compensation awarded or fixation of liability on the insured appellant for the accident. The same shall be paid within 2 months from today after adjusting what was paid earlier. Now, where do you get it? It's not there. Because it doesn't go with it. If you have to say pay and recover, there should be some violation.
Uninsured trailer, it has attached to the tractor.
Court says, court says there are two issues. Applying the pay and recover, considering the plight of the third party is a different aspect. Now, in this judgment, Honorable Apex Court said that it is not required. Please look at it. Yes. Because in the penultimate paragraph, you don't see that.
Judgment also says that same thing. Pay and recover. Para 19 not. However, liberty is granted to the appellant to recover the.
Where are you reading?
Para 19. For the reasons aforesaid, we do not find any information of impugned order there.
However, liberty is granted to the appellant to recover the differential amount in terms of paragraph number 18 supra. That's it.
It is differential amount.
We'll go to this paragraph number 18. What is this paragraph number 18? Because when what emerges is that the appellant ought not to be saddled with payment of compensation exceeding what the insurance policy provided. That pay and recovery is from the owner. That exceeding amount, the claimant can recover from the owner of the vehicle. Insurance company can only pay as per the. Please read 18. Appellant is an insurance company.
What emerges is the appellant would not to be saddled with the payment of compensation exceeding what
the amount exclusively payable by the appellant. It is very clear. 18, paragraph number 18.
Paragraph 18, what emerges that
yes.
The appellant would not be saddled with the payment of compensation exceeding what the insurance company policy provides for the
limit, if any.
Set under the law for the time being imposed, whichever the higher amount of the two, the underlying factors, the amount exclusively payable by the appellant over shall Yes, be less than 9,50,000.
So now the amount that is granted is above 9,50,000. That excess amount will be recovered from the owner of the vehicle, but the appellant insurance company will pay only 9,50,000.
That is WC matter.
Restricted to WC. He is an employee who is owning the vehicle. I had to pay to extent of WC policy. That's
What is that amount? What is that?
Refer on that. Indian Motor Tariff provision, AMP 48 has been mentioned. The liability is only restricted to WC.
How much is the amount then?
9,50,000.
Then relevant.
Give the TCR. Let us see the policy.
8,000. Relevant factor has to be applied.
Yes.
4,000 into relevant factor.
1 minute.
Policy exhibit, sir.
Policy is exhibit.
Exhibit
R1.
You have the copy?
Exhibit R1.
Yes, let's see.
Policy, sir. Nodilla.
Give it to him. Let him show. Anita, give it to him.
Enhancement is IMP 28.
Hmm.
It also says the same thing. It is employee being carrying the vehicle.
Hmm.
The liability is restricted to this act.
Loader unloader is also an employee. Hmm.
The same scenario affects for the vendor. MP has been mentioned.
Hmm. That's why what they said was, whatever your liabilities, they've said it is
WC liability, I have to pay the company.
9,50,000 is something is shown in that.
Something not just that, but here may not 8,000 would be the wages.
8,000?
What wages?
Hmm.
4,000 of as
50%. Hmm. Hmm.
into relevant factor.
What is the factor? His age is 21.
Chart itself is mentioned.
Chart, where is it?
Chart itself is mentioned.
Oh, in the chart. Which chart?
Lokadala chart.
Lokadala chart, the factor is not there.
Is there? That's there. You have given answers.
200 and? Oh, in that it is not there. Factors are not there. So how much it will be?
224. 224.
224. So 4,000 into 12 into 24. Only just 24. Is coming to 8,96,000.
With interest at 12%, my lord.
Into WC it is 12%. 12%.
12% interest.
So,
from the day, 30 days from the date of accident, my lord, it is to be considered.
30 days from the date of accident.
Please, my lord.
So, what is the differential amount now? How much the court has arrived at? Give that calculation. Calculation.
13 lakhs.
13 lakhs? 200 minus 8,96,000. It comes another 4,79,200. It has to be recovered from the owner. What happened to the owner? Notice to the owner is served in this, or you have asked for dispensation?
Proxy counsel, my lord.
Look at it. Give that.
It is served or
What the cause list says?
Srinivasa served. K. Srinivasa served.
It's served.
Govinda served.
It's served. So 4,79,200 has to be recovered.
12% is to be.
That is there. That I understood. I'm saying the remaining amount has to be from the owner. No, I have marked the different portions also. Entitlement.
Remaining amount,
extra.
my lord. For remaining amount, my lord, 6% interest.
For 8,96,000, 12% interest.
In his contentions, it is submitted that they're entitled for compensation as per the Workmen Compensation Act. And this accident had, the wages have to be taken at 8,000. And as is a case of death, 50% is 4,000 into the relevant factor. That is the only liability of the insurance company, and they cannot be made to pay the entire amount. It is submitted that even in the judgment that is referred by the counsel for the petitioner, the Honorable Apex Court had permitted them to withdraw it from the owner of the vehicle. Next para, I've completed the narration, end of it, after the loss of dependency and all. Now, how much the insurance company is liable to pay as a policy, is it? What is that? No, that some 14 something is
28. IMD 28.
IMD 28, where the liability of the insurer is as per the Workmen Compensation Act, taking the income at 8,000. 50% of it is 4,000 to relevant factor, that is 224. It comes to 8,96,000. And the compensation that is awarded by this court is 13 lakh. Give that 13,75,200. Then if this amount is deducted, the remaining amount is 4,79,200. Hence, the insurance company is liable to pay 8,96,000 with 12% interest. 12% interest, and the remaining amount of 4,79,200. Owner of the vehicle is which respondent here?
Second respondent.
The second respondent is liable to pay the same, and that shall carry 6% interest. Yes. Next.
Cell number 2. Cell number 2, Pradeep B for appellant. Syed Abdul Sabur.
This also you keep it, no? Both. That along with that, this also. Yes. What is 2 and 2.1? Your appeal is also there. You are on what ground?
At some time, as per exhibit P6, self fall from the two-wheeler, in the
Self fall they are claiming, but actually, initially he was admitted in Krishna Hospital.
Last time I heard it. Why is it adjourned?
MLC report.
The admin friend has to address the argument. For his
He was not there on the last occasion.
Yes, took a time.
I had to produce the document.
You have it?
Yes, ma'am.
But it was not marked before the court. It was not marked before the court.
Not much.
How can we take the document just like that now, which is not marked before the court? What is that you're seeing? MLC.
MLC.
Copy, MBA. I think MLC is not placed before the court. File with an application under Order 41 Rule 27. Yes. And just like that, we can't take it.
Even the IMD report also.
It is there in the IMV report.
IMD report.
What it says?
Damage is there. Mechanical condition of the vehicle. In both the vehicles. If it has been
The land counsel for the the claimant submits that the MLC is not marked before the court. He has a copy of the same, and he would be filing it with an appropriate application. Delete from part 3rd, and the petition is permitted. The claimant, the counsel for the claimant is permitted to file this application within a period of 2 weeks from today. Yes, list
number
after the
3.
application is filed.
For dismissal, cell number 3, Vijay
Yes.
Kumar D, Nantraj K for respondent.
very for responding number 4.
Where is Mr. Vijay Kumar?
Vijay Kumar D.
Do that. On 23/7/2025, as there was no representation on behalf of the MLN, the matter was directed to be listed today under the caption for dismissal. Today also, there is no representation on behalf of the appellant. Accordingly, the appeal is dismissed for non-prosecution.
Serial number for order, serial number 4.
I pray for time to pay the process for the second time.
Needful shall, the process shall be paid within a period of 1 week, default order. Then what about non-depositing of the entire amount before this court?
Lords are obtaining peculiar facts in this case. Award is 10,000, which I have deposited along with the appeal. Lord, by mistake, I did not see with interest. That interest component is not deposited.
The interest shall be it is submitted that he has deposited the entire amount but not the interest. The same shall be deposited within 2 weeks.
Lord, could this be disposed of? Lord, there are 4 matters. In all the 4 matters, award is only for 10,000. Passengers in the goods vehicle to whom insurer has.
But the service of notice shall be completed.
Yes,
Once it is
ma'am.
completed, clear. Give the list, we can dispose of.
Stay has been vacated.
One submission, my lord.
Arise.
What is that?
Stay has already been vacated by this honorable court. Therefore, he may not be required to deposit that paltry amount, which ultimately after disposal.
Stay is already vacated. Just say needful shall be done within a period of 1 week, default order. Yes, next.
With your lordship's kindly, my lord, serial number 3, my lord.
Why were you not there?
My lord, I am in quota number 5, my lord. Sorry, I have been following from morning from 10:30.
Then your respondent advocates
My lord.
delete from the caption dismissal. The 3 which is dismissed, delete from the caption dismissal. List the matter. Inform the other side also.
Yes, my lord. He is also in quota number 24. Mr. Shantraju is in quota number 24.
Then argue there. List this matter on 10th.
Much obliged.
Serial number 5.
Yes.
Serial number 5 for IA order Chetan DT.
Till now, what is this?
Recalling.
Yesterday you asked for time.
Yes, sir.
Yes. It is appeal by whom?
Petitioner for enhancement of the
That's what I'm asking.
king enhancement.
Hmm?
King enhancement. Injury
Then
case.
what about all these IAs? First of all, IA number 1 of 23.
Delay.
And no representation on at least 7-8 occasions.
Sorry, my lord. My choose.
Huh?
File is misplaced somewhere.
Same story every day we can't hear, Mr.
No,
Kamsa.
I am ready to this way today.
Every day I can't
Kindly
hear.
password. I'll get the file and.
You are taking it very, very casually, I'm telling you.
No, sorry, my lord.
Very casually you are taking. Yesterday, same submission is made. Today morning, same submission. And from the last 8 occasions, you don't appear before the court.
Sorry, my lord. I
Passed over. But anyhow, I'm going to dismiss it. I'm very clear on that. Yes.
Serial number 6. Serial number 6. Gurunath TS.
For respondent, my lord. Respondent is the claimant, my lord. They are challenged at the liability, my lord. I have filed for the return of LCR, my lord.
But when the liability is challenged, you can't. withdraw the
Already,
amount.
honorable court has order for 2 lakhs rupees released the order. Kindly peruse the order dated
We'll hear it. Are you ready?
99.
Yes, my lord.
Yes. 2 vehicles are involved. 2 insurance companies.
Who appeals?
You appear for?
I appeal for the
Owner of.
owner.
Liability is fixed on the owner.
Yes.
Let's see. On what ground?
My lord,
There is
in
no
fact,
DL, my lord.
actually,
No DL.
Pay and recover will apply. Owner separate. No, but what happens to him? Oh, he has not prepared any appeal.
I am also cross objection also pending, my lord. 6.1, my lord.
File.
Yes, my lord.
And then?
This matter, let him build a cross objection.
Yes, now,
There is a scope of
considering
enhancement.
that, no pay and recover will apply.
Please.
So according to you, why what is your stand?
he has not been discharged in KC General Hospital.
he has gone out of the hospital without the instruction of the doctor.
No, there are two things. Are you arguing on your liability, or are you on the that he is not entitled for compensation?
He is not entitled for the
So
compensation.
please come on why he is not entitled.
That's what, my lord. Actually, it is of the negligence of the deceased. He has died.
How it is proved by you?
That is because
Why you
they have
examine?
not furnished the discharge summary itself.
Why you examine?
Pardon?
Why you examine before the court?
When we came to know that, when we came for appeal, then we went to KC General Hospital to take the wound certificate. At that time, we found that he has not been discharged.
Have you contested the matter before the trial court?
By that time, the trial court, it was already judgment was passed.
What is by the time? By the time notice served to you?
Pardon?
By the time notice served to you?
Yes, my lord.
Notice
At that
is
time,
served,
it was
you are-
notice was served.
Okay.
But there, what happened? The case was conducted at Davangere. So their advocate was some other person, and he did not take any initiation. And when it came to appeal,
But unfortunately, your client is one and the same, before there or before here. So,
yes, my lord. But his
when
lack
you
of
have not, when you have
lack
not
of knowledge
contested
of
the matter, that we cannot consider now. You have to
That's
be,
the
you have to
main-
examine yourself.
because
you have to lead
later on
evidence.
we also got known that he was suffering from liver problems, and on that basis he has died. But they have taken this.
Where from you say that he has died from the liver issue, but not, where is the certificate?
His relations told me. That's what.
That's
When we went and asked.
We can't
hey,
consider all that. We can't consider.
No, because at least suppose he has died from the accident itself, then he
Burden
should
lies
have.
on you. How did you discharge your burden?
Means actually, my lord, the thing is, now he has to furnish the discharge summary of KC General Hospital. They have not furnished that thing. When they have not furnished that thing, we went to KC General Hospital and we found that he has gone without the permission of the doctor. Like forcibly he has gone. And after 10 to 12 days, after that, he has joined there in the some other hospital in Davangere.
Please give that, this here.
Exhibit P4, my lord, postmortem report. It clearly reveals that the death is caused due to.
Postmortem report consider madak
What
barudilla.
else you want? Exhibit P4.
Postmortem
Take out
report.
exhibit P4. And please come to the liability part where it is. In this regard, the charge sheet reveals that as on the date of the is not holding the. Yes, please come. Take out exhibit P4. Agreed with the award passed in MBC number 679 of 2016, dated 11th. You are seeking enhancement also.
Yes, my lord.
Claim petition filed by the mother here. During the pendency of the appeal, the mother died.
Nobody is there.
No, that's what. During the pendency of the appeal, I am saying. During the pendency of the appeal, I am saying.
Okay. So let's see. Then who is the LR now?
LR is the already brought on record, my
Who are
lord.
they?
Sister, my lord. Sister of the deceased.
Deceased. So
You have mentioned brothers.
who that is LR petition is ordered.
You have filed amended appeal memo. That's what I am seeing. Not
Daughter of the.
Not amended appeal memo. LR petition ought to have been filed. Ought to have been allowed. When
Allowed.
was it? When was it ordered? In the amended appeal.
Amended affidavit filed. Copy is given, my lord.
Died represented by her legal heir.
Yes, my lord.
Vijayalakshmi is the daughter of that lady.
Yes, my lord.
And Daughter is implicated.
Yes, ma'am.
Wife of so and so, presently aged about 50 years.
Yes.
Recent appeals for judgment.
What it says?
Married daughter.
Huh?
So far as married daughter is concerned, my lord, they are not entitled to
No,
loss of
for the amount. Already by the time she was, as on the date of the appeal, she is alive.
After judgment.
Even during the MBC, all the calculation is based on that.
My lord, as far as enhancement is concerned, however, the amount is already has awarded 8,85,000. They are seeking further enhancement. Should not avail this.
There is a scope of enhancement, my lord. Since the future prospectors not awarded, my lord, and the income
No, if they argue about loss of dependency,
Yes,
as you are not dependent, now the legal heir is the sister, then that if manovolence judgment is applied, and if we take 15% of what is granted, it will come to 0.
please, ma'am. Please.
Agreed by the award passed in MBC number 679 of 2016 dated 11 June 2016, whereby the court had granted an amount of rupees 8,85,000 and the liability is fixed on the owner of the vehicle. The owner is before this court by filing MFA 3717 of 2020, and in that MFA crop 38 of 2024 is filed by the claimant. Then counsel appearing the claim petition is filed seeking compensation of an amount of rupees 25 lakhs for the death of the deceased. It is a case that on 12/4/2016 at about 3:45 p.m. in the evening, while the deceased was proceeding on the left side of the road, the driver of the swift car drove the vehicle in a rash and negligent manner and endangered two motorcycles and car, and finally dashed against the pedestrian. As a result, the deceased, who was a pedestrian, sustained severe injuries and immediately was taken to the KC Hospital, General Hospital, Bangalore, and later on shifted to SSIC Hospital, Davangere. And on 24/4/2016, he died due to accidental injuries. The tribunal has fixed a liability on the owner of the vehicle as the driver of the offending vehicle was not having a valid driving license at the time of the accident. And when it comes to the compensation, court had granted an amount of rupees 8,85,000. Learned counsel appearing for the appellant claimant owner of the vehicle submits that there was no sufficient proof on record to show that the death has occurred because of the accidental injuries. It is submitted that when he was admitted in the KG General Hospital against the medical advice, he left the hospital, and later he joined in the other hospital and died. It is submitted that as per their information, he had liver issues, and because of that he died. And the court, without any evidence on record with regard to the accident and the connection with the same to the death of the deceased, has held that has granted the compensation. It is submitted that it is a contributory negligence on the part of the deceased, and there is no negligence on the part of the driver of the opposite vehicle. As such, the claimant are not entitled for compensation. The learned counsel appearing for the insurance, the claimant submits that as there was no driving license to the driver of the offending vehicle, the same was the court had held fastened the liability on the owner of the vehicle. It is submitted that in the light of the settled law in Swaran Singh's case, that is Swaran Singh versus so and so, reported in so and so, the insurance company is liable to pay the compensation and recover the same from the owner of the vehicle. And then counsel appearing for the insurance company submits that the court had rightly considered and fixed a liability on the owner of the vehicle, and the compensation that is awarded is just and reasonable, even on, and no interference is called for. Next para. Having heard the counsels on either side, peruse the material on record. The owner of the vehicle has not contested before the tribunal, has not adduced any evidence, nor he has entered into the witness box. Now, the contentions that are raised is there is contributory negligence on the part of the deceased. If there is a contributory negligence on the part of the deceased, and if that is the case of the insurance company, the burden, the owner of the vehicle, the burden lies on the owner of the vehicle to prove the same. In this case, no such effort is made and no evidence is adduced. Then
One submission. If the case is remanded back to the trial court, I will call KC General Hospital and
it is not the postmortem certificate is marked as exhibit P.
4, my lord.
P4. The postmortem certificate is very clear that because of the accidental injuries, the death had taken place. That itself is sufficient to say that there is a connection between the accident and the injuries. In these circumstances, this court is not inclined to consider the submissions made on behalf of the owner of the vehicle. And the court had rightly held that accident has occurred due to the rash and negligent driving of the driver of the offending vehicle, and it resulted in the death of the deceased. Then coming to the liability, in the light of the law later on in Swarensing's case, referred supra, the insurance company is liable to pay the compensation and require the same from the owner of the vehicle. Accordingly, the appeal filed with the owner of the vehicle is dismissed, and the appeal filed with the cross objections are allowed, holding that the insurance company is liable to pay and require the same. The amount in deposit shall be transmitted to the court, and the claimant is at liberty to withdraw, and the remaining amount the insurance company shall deposit.
Still at 18,000, the owner has deposited rest of the amount.
Yes, you have to the remaining amount the insurance company shall deposit.
Record the same from you. Record the same from you.
Record the same. Pay and record already said.
Legal layer of the.
What is that?
Withdrawal is in favor of the legal layer of the claimant.
Yes. In 6.1, for the insurance company, Mr. B. Pradeep, as he is appearing in the connected matter, he shall file the wakalat, and for the owner of Mr. Gurnath C.S. For the owner of the vehicle, and he shall also file wakalat within 1 week. Yes, next. Yes. What is this IA 125 paper publication? Office objection. What are the office objections? Office objection shall be complied within a week.
Your Lordship.
Yes, next date.
One more submission, Your Lordship. There are four connected matters to be posted along with Your Lordships.
You have to give this all the matters. Somebody has to give the list. 4 matters. Give it to the court officer.
I will.
List along with so and so connected matters list. Yes, 8.
7. Cell number 8.
For the appellant,
what is this?
There are totally 5 appeals have been filed by the corporation, my lord, and all the 5 appeals I got the stay, and emergent notice has been issued. I have paid the process on the very next day, my lord, for all the 5 cases, and the office has sent the notice for 4 cases, and the opposite people have filed the wakalat, and even they filed the application for withdrawal of the amount that has not been listed. I have a copy that having filed that even.
What is that? What is the numbers you give? We will post this matter along with that.
Yes,
we'll ask them to take notices. Then we will recall this order.
No, the dismissal has to be restored, my lord. Otherwise,
that
they
we will
won't.
do. First of all, what are the other numbers?
Yes,
that day itself will do.
I have already stated in my also. I'll give it.
Just along with so and so on Tuesday.
Connected matters, I'll give it.
Yes, yes. On Tuesday. Yes, next.
Cell number 939.
For the appellant, the first matter, my lord.
Yes. You appear in 9?
First list.
Ravi Shankar, Raja Ramesh.
A. Ravishankar.
Uh,
I appear for the insurance company.
yes.
Case of death.
Who appears for the respondent?
Raja Ramesh.
And other appeal is you appear?
Please, madam.
On what ground insurance companies?
You know, the claimants are the working sons. They are they are the working sons. They are not financially dependent on the deceased. That's all is the point.
Latest judgment.
Birendra's judgment, it is sufficient. my-
Later judgment also.
That itself is sufficient, my lord. This may be
But they
disposed
cannot
of, my
claim
lord.
under the loss of dependency. They cannot claim. A loss of estate can be awarded, my lord. They were not financially.
That is not the judgment. But what is the age of the claimants?
46 and 54. And they have admitted in their evidence that
Birendra's case and the later cases, latest judgment also, there the children were major sons, but they were in the age group of around 29, 30. Then the court had dealt it in a different
Then
way.
I will also provide suitable citation. I will be given start date, my lord.
Get those judgments. What
Birendra's-
is the judgment, Pradeep? Prashant Kumar Mishra's judgment, latest, referring to Birendra's case. That is there, no?
Voice
No, we have the copies. no?
Birendra's judgment actual.
We have the latest judgment of Prashant Kumar Mishra, which is like little taken it forward.
Seema
Huh?
Rani.
Seema Rani's case. Look at it. Look at Seema Rani.
Please, my lord.
Your case fought 50 years. So you can't compare your case with either Birendra or Seema Rani.
Next week, may be taken, my lord.
Then Manoval again will have to be applied.
One. Next week, it may be taken.
Next week, list this matter on 11th of September.
Much obliged.
Yes.
Cell number 10. For admission, cell number 10, Kalpana PV, B Pradeep.
Your other matter is, he has
my
again
lord, I
mentioned
have,
morning dismissed matter.
Huh?
Vijay Kumar, given some other dates.
That matter, tribunal has granted
My
You're
lord,
on what ground?
owner, I'm the owner of the tractor trailer, my lord.
Owner of the vehicle,
Yes,
you are.
and he appears for the claimants, my lord.
Huh.
My lord, the liability is fixed on the owner, my lord.
On the ground?
On the ground that the deceased who was traveling in my vehicle was a gratuitous passenger and not the loader or cleaner. There is no violation of any policy condition as such, my lord. The policy covers there is an insurance and there is no there is no violation as such.
It's a vehicle.
Tractor trailer, tractor.
Who is he?
My lord, he was a loader.
Loader. Oh.
Yes, my lord. And it covers, they have taken 75 rupees, my lord.
Who appears? Pradeep?
Pradeep appears.
You don't have the policy.
Just
Give
because.
Take out the TCR. Give it to him.
TCR not yet. It is still in admission, no ma'am. TCR is not.
Oh, it's not yet. You have the copy.
policy.
Give it to him. Then these matters.
In my RPS practice, he has been dismissed as an insurance company. I don't come across such a.
Any of this 2085 days will
My lord.
condone on condition.
Yes, ma'am.
Will condone on condition. I number 1 of 22 is filed to condone the delay of 2085 days considering the reasons stated. Delay is condoned on the condition that will not be entitled for interest for the set period. Yes. No, 10 point.
Owner.
10 point.
Delay is in his
appeal.
That is in the claimant's appeal. Delay is in claimant's appeal. For the respondent insurance company, Mr. B. Pradeep is directed to take notice. The registry is directed to call for the TCR telephonically. List this matter on 18th of September. Yes, next.
Cell number 11. Cell number 11, D. Vijay Kumar.
Again, he will come after the matter is adjourned. That's what he will come after the matter is again. Next matter is called. He will come. Shall I pass over? Inform me. Tell him or else in the afternoon, straight away we will dismiss it without posting it for dismiss. Yes.
Cell number 12.
This case appear for appellant, I filed for enhancement of the compensation and
Vijay
the
Kumar is appearing. We'll have it pass over.
we will archive the case.
Huh?
230.
That's what.
Pass over, yes.
Yes. 13.
Cell number 13.
I appear for the respondent in this case, my lord. My lord,
Appellant, madam.
You're for the appellant.
Appellant.
He also says he's appearing for the appellant.
I appear for the respondent, my lord.
BC Prabhakar.
Please, please, my lord.
Respondent, madam.
Hmm.
That claim petition was dismissed only on the ground, madam. Claim petition filed by the bar by limitation, madam.
When is the accident?
That accident took place on 14/2/2019, madam. Claim petition filed on 13/9/2021.
Why?
The WC petition, madam. Madam, there is a 15/3/2020 to 28/2/2022. There is a COVID pandemic period. Limitation is exempted. Therefore, the petition was not filed and application was not.
My lord, kindly read the, kindly please peruse the para 20 of the order, my lord. Issue number 2. May I read that, my lord?
Yes.
It is the contention of the respondent that the petition is not maintainable as it is barred by limitation. Section
Yes.
10 of the Employees Compensation Act provides that the claim, if any, is required to be filed within 2 years of the occurrence of the accident, or in the case of death, within 2 years from the date of his death. The admitted fact is that the late Ramu died on 14/2/2019, hence the application is time barred. Further, this is important, my lord, the petitioners have not filed any application for condoning the delay in filing the claim. The petitioners are required to submit an application explaining the reasons for delay of each day. Hence, the application of the petitioners is liable to be rejected on this ground alone. And there is no basis for holding further in this.
For in 2 years' time, it is provided, even if you count 2019, 2021. It's almost, it's coming within. Only thing is, little delay is there for which Section 5 application is not filed. We'll give them the liberty.
At least an application should have been filed, my lord.
That's why we'll say that.
How could the honorable court take so much to
No,
take that?
for all this delay, whatever it is, because he has not filed the petition within time, we'll say that he is not entitled for interest. Yes. What do you say? Yes, Mr. Counsel, for the respondent, what do you say?
Please, my lord. Please, my lord.
What do you say? I'm saying we will remand this matter and will say that for the delay, for the period which is pending before this court, he will not be entitled for any interest.
Please, please, my lord, please.
Yes, please come.
And quantum also not assessed by the
That will be assessed now. Anyway, we're sending it back. The agreed with the award pass in ECA number 2 of 21, dated 15th November 2022, whereby the court had dismissed the application, dismissed the petition filed by the petition appellant seeking compensation. It's a case of death.
Death, my lord.
For the death of the deceased. In this case, the accident had taken place on 14/2/2019, and the incident petition in the ECA is filed on 13/9/2021. As per, the court had considered the section 10 of the Employees Compensation Act, and where the application needs to be filed within 2 years of the occurrence of the accident, or in case of death within 2 years from the date of his death. In this case, when there is a delay, then no application is filed seeking condonation of the delay, and without filing the application, the appeal is filed. As such, it is dismissed as not maintainable. Next paragraph. When counsel appearing for the appellant claimant submits that the death was during the pandemic time, and as for the standing operating procedure SOP that's prevalent, the court ought to have considered the case. That too, it is a case of death. On these kind of technical reasons, court ought not to have dismissed the petition. Next para. Learned counsel appearing for the respondent submits that the claimant had not even taken minimum care to file an application under Section 5 of the Limitation Act, and the court had rightly dismissed the petition, and there are no grounds to interfere. As per next para, having heard counsels on either side, there is a material on record. As per Section 10 of the Act, it has to be for 2 years from the date of the death. In this case, death is on 14 to 2019.
14 my lord, on
And
the
in
same
this
day.
case, the death is on 14 to 2019, and the application is, and the petition is filed. Application is filed on 14 to, on 13/9/2021. There is a delay, and no doubt that was the pandemic time. The appellant ought to have filed an application under Section 5 of the Limitation Act. But unfortunately, in this case, it is not filed. And the court should have seen that initially, if it is raised as objection, it would have been what did you write?
It has been raised, my lord. It has been raised.
Unfortunately, that's not, that is not filed. But considering the fact that it is a case of death and is entitled with the compensation, it cannot be denied on this.
My lord, my lord, whether he is entitled for compensation or not is required to be decided, my lord.
That's what, as of now, as of nothing has been decided, their right is,
Please.
he has a right, whether it is there or how it is, it will be decided.
That has to be
Person
decided.
has a right to claim the compensation, and it has to be decided by the court on the facts and circumstances of the case. But at the threshold, on this ground, the petition cannot be dismissed. And at the same time, further delay and further latches on the part of the claimant, in case the application is allowed, the respondent cannot be burdened with the interest. In those circumstances, this court deems it appropriate to set aside the order impugned on the order accordingly. The order dated so and so is set aside. The matter is remanded to the court for fresh consideration. The petitioner is not entitled for interest for the entire delayed period, and from that date till now is not entitled for interest. The court, the parties without further notice shall appear before the court on 18th of September, and considering the fact that this accident had taken place in the year 2019, the court shall consider and pass appropriate orders within a period of 9 months. Yes.
Till number 14, Jagdish H.T. for appellant, Radha B.P., L. Srikant Rao.
Yes. Huh? You come this side so that you'll be able to argue. Both are respondents. Then where is Mr. Jagdish H.T.?
Not been.
Petition is dismissed.
Petition is dismissed on the
List this matter for dismissal tomorrow. No representation for the appellant. Yes, next. 15.
Cell number 15.
I am for the enhancement, my lord. Notional income, they have taken too less.
Mr. O. Mahesh.
I'm not, I'm rest.
O.
In the
Mahesh.
second matter, ma'am.
Raja Ram Surya.
That's what I'm saying.
Notional income, they have taken
In
less.
15.1, Mr. Rajaram S.
O.
Please,
Mahesh.
please, my lord, for enhancement,
1.
notional income, they have taken.
1 minute. Mr. Rajaram S. is directed to, already you have filed.
Please, my lord.
Oh, no representation for the insurance company. Counsel for the respondent claimant, counsel for the claimant is present. List MFA 5583 of 2019 for dismissal on 3rd of September.
Much obliged.
Cell number 16. Cell number 16.
Yes, Mr. Jonathan, who appears for the respondent?
Respondent is in hospitalized, my lordship.
He's not well. Counsel.
Yes, my lordship.
It is submitted that counsel for the respondent is unwell List the matter on long day.
Yes, my lord, because the last 3 months he is not being there.
This is the matter in the month of December, December 18. Yes, 17.
Cell number
One
17.
submission, my lord. One
No
submission.
submissions, Mr. Vijay Kumar. It doesn't go like this.
Yes.
Please note the mention in between. Yes.
17, Pradeep ji.
It is connected with serial number 4, my lord. Granted me time to take
Oh.
step.
To take steps. R1 in the,
So in that R1 in that is represented in these cases?
in my cases, my lord,
Huh?
connected my matters, my lord, 17, my lord. 17, my lord, he has been served, my lord. Sumitra.
No advocate is appearing.
No, my lord.
So list these matters along with what is that? 8.
4, serial number 4.
List these matters. List these matters along with 4.
Cell number 4. In list 1.
4 appeals preferred by me, my lord, and 4 appeals preferred by the another company.
Serial number
So these can be disposed of when this service is completed. Then we will complete. We'll hear these matters. We can hear these matters. The same thing will follow in the other matter also.
Please.
Yes.
Connected matters, in all the connected matters, my lord, R1 in the appeal prepared by senior advocate, my lord, is not served.
R4, the manager Cholaman.
R4, I will take, my lord, I will undertake.
You will take. Then you can argue. You can file a wakalat later, or you want to file wakalat. If it is any inconvenience, we'll adjourn, or else you can
No,
argue.
madam, no, my lord, only the 2 issues are involved in this case, my lord. I am the insurer of the tractor, my lord. The driver of the tractor who doesn't have driving license to drive the tractor, my lord. And their contention is, my lord, so many persons for traveling in Tata Ace as an unauthorized passenger. That is their contention.
Can we hear or next?
Give the synopsis.
In all these where Mr. Sita Ramarao has filed the appeal, in that in all R4, that is 17.1, 17.2, 17.3, 4, only till 17.3 for Cholamanda general incident, Mr. Pradeep is directed to take notice. Then all are your appeals. Yes, all these matters is directed to take notice. List all these matters on along with that item number 8. Post along with yes. 4. Yes, post along with 4. Yes, 18.
Cell number
In the meantime, you file wakalat.
Please, madam. Next date.
Along with that, because it's 1 week's time is granted for complaints.
Take steps. No, madam, owner is represented, that's what.
Represented.
Other cases, the owner is represented.
You will take notice in 8. No, for that one, if you come to this
4.
4.
What is the response for 4?
4 non-deposit, that is furnishing R1 for second time. R1 is the owner.
No, my lord, R1 claimant. Serial number 4. I'm saying serial number 4.
And that's what I'm looking at. Serial number 4. R1.
Notice so R1 is the, who is also claimant.
R1
Claimant. Oh, that's what.
Served alva, sir.
Who is the owner in MFA 2266? R2 is some Timmesh, R3 is Timmeshi, R5 Basappa, R6 PG Kumara. If you PG Kumara, what is your name? So and so in 4.
For whom
So and so submits that he has instructions to file wakalat. You write, please write the name. For R6, he has instructions to file wakalat. List all these matters.
R6 PC Sitaram Ravi is there.
Yes, next. Date, I've already given the date. Along with that, along with this, whenever the notices are served. Yes.
Cell number 18 adjourned. Cell number 19 Gopal Krishna.
I appear for appellant in this case, my lord. My lord, we are on the ground that the tribunal erred in deducting 50% on the personal and living expenses of the deceased, my lord. The tribunal failed.
1 minute, Mr. Pradeep.
BC Shivane Gowda. Cell number 19, sir. Pradeep.
Are you appearing?
Pradeep.
Yes.
Only on one ground, my lord. The tribunal erred in deducting 50% personal and living expenses of the deceased The tribunal failed to appreciate that the claimants are wife and three major sons of the deceased, my lord. When wife is the only claimant, deduction towards personal expenses of the deceased should never exceed 1/3.
Yes, yes, yes. That is one. The next.
Deduction at
Only
50%. Yes, my lord. And there on the appeal, that corrected matter 19.1 is also there, my lord.
Yes. On what ground the insurance company is here? To the file. One is sufficient. They're only that 1/3 and 50% they are on that.
Deceased was aged about 70 years, my lord.
You are also on
70 years.
quantum only.
Please, my lord.
Yes.
And driving license, my lord, is also taken, my lord. The tribunal should have noticed that the
Come to
appellant
the liability.
discharged the burden, calling upon the owner of the auto rickshaw to produce the driving license, my lord. They have failed to produce the driving license.
No. Is a crime registered under the provisions of the MB Act?
No, ma'am.
If it is not there, there is no other evidence, we will not consider that.
My lord, FIR complaint, copy of requisition, everything has been.
They have taken a ground that, my lord, the owner of the vehicle was not produced the driving license.
General ground.
Kindly pay and recovery order may be made, my lord.
No, why should we grant pay and
And
recovery
future
without any
prospects.
basis?
And future prospects added for 70-year-old deceased, 5%.
How is he entitled for future prospect?
A future prospect is not entitled, my lord.
And interest awarded 8%.
So let's calculate. What is
Yes,
the age?
please.
70. Which year is the accident?
2019, my lord.
What is the amount?
MSCT has rightly considered the income, my lord, 14,000 per month.
No. It is deducted 50%.
Please, my lord.
Wife?
My lord, 70-year-old person, my lord. In
I'm
not
sorry.
all the cases, my lord, 1/3, my lord. My lordship was only held that, my lord, 58-year-old, my lord, daughter. 58-year-old daughter.
No. We are not considering them. I am not considering them as dependents. But in case of a married person, you can't apply that the bachelor 50% we will not deduct.
No, my lord. Here, my lord, the claimants are, my lord, the married daughter and 41-year-old son, 139.
Not considering all of them as dependents. In case of a wife, husband.
No, here
single-
not, wife is not there.
She's
Wife
there.
is there, my lord. Wife is Jayamma, appellant number 1.
Emma is the wife.
Yes, please, my lord. Deduction at 50% towards personal
Yes, 41 years shown, my lord. That's what
We can't help it. Wife too is there.
Yes, my lord.
So, what income is 2019, what is
14,000.
14,000?
Per month.
No future prospects. One. Multiplier is 8.
No, my lord, 5, my lord.
5. It comes to 5,60,040. How many are the claimants?
4, my lord.
4, my lord.
4 into 44. 1,76,000. 36,000. Seven lakh 82,040. What was granted?
6,31,000.
6,31,000. So you are on number 1 interest. Then
Interest 8%. And my lord,
and second one is
added 5%
future prospects were granted.
granted.
Then
And so far as driving license, my lordship may notice that, my lord.
I'll only record.
Please.
Please come. Agreed with award passed on MBC number 322 of 2019 dated 15th October 2022. Both the insurance company as well as the claimant are before this court. Insurance company's appeal is MFA 1091 of 2020 and the claimant's appeal is MFA number 8146 of 2022. The claim petition is filed seeking compensation of an amount of rupees. How much? Seeking compensation.
20 lakhs. Ma'am.
Seeking compensation of 20 lakhs for the death of the deceased in the accident. The deceased is aged about 70 years. And the court had granted compensation of an amount of rupees 6,31,000. Learned counsel appearing for the petition, appellant claimant submits at the court and granted the compensation as per the table given below, extracted. Learned counsel appearing for the claimant submits that the court ought not to have deducted 50%. It ought to have deducted 1/3. It is submitted that on the other grounds also, on the other heads also, the amount that is awarded by the tribunal is on the lower side. Next part. Then counsel appearing for the insurance company submits that the court had rightly deducted 50% as her wife is the claimant and others cannot be treated as the dependents. It is submitted that the court has granted 9% interest, which is on the higher side. It should have
8%.
been at,
8%.
8%. It should have been at 6%. Further, the deceased who is 70 years old, the court had granted future prospects, and the future prospects of not have been granted. It is submitted that the driver of the vehicle has failed to produce a driving license, hence the court ought to have granted pay and recover, which is not done in the case. Next part. Having heard the counsels on either side, there is a material non record. First, coming to the liability. It is a case of the insurance company that the owner of the vehicle has not produced the driving license. And apart from that, there is nothing on record to show that the driver of the offending vehicle is not having a valid driving license. Even as per the charge sheet also, no such crime is registered in the provisions of the Motor Vehicle Act. In those circumstances, the stand taken by the insurance company is untenable and this court is not able to appreciate the same. Next, coming to the, before that, the court had rightly held that insurance company is liable to pay the compensation. Then coming to the quantum, as rightly argued by the learned counsel for the insurance company, a person of 70 years is not entitled for any, is not entitled for future prospects. Court had wrongly taken the same. Considering the 40%, 14,000 as an income, consider as the accident is of the year 2019, as a wife is a surviving the dependent, this court is deducting 1/3, that is 4,666, and his contribution to the family is 9,334 into 12 into 5. Our loss of dependency is 5,60,040. Consortium for the 3 children and the wife 4 into the 44, 1,76,000. Funeral expenses 36,000, and in the light of the law laid down in so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 7,82,040. Accordingly, the appeal is partly allowed, enhancing the compensation from so and so to so and so. The amount, the interest, the entire amount shall carry 6% interest.
Amount in deposit.
Amount in deposit shall be forthwith transferred.
Much obliged, my lord.
Or both the piece are partly allowed. Yes, next.
Then number 20. 20, Shantraj K. For appellant D. Vijay Kumar.
20 and 20.1. No representation on behalf of both the parties. List the matter on 18th of December. Next.
List number 2. For dismissal, sale number 1. Monica Patil.
Your Lordship, I am for the petitioner, Lordship. I filed a memo for retirement, Your Lordship. Same may be considered, Your Lordship.
Where is the memo?
I had filed on previous date, Your Lordship.
What is this memo of retirement? Is it the way to file the memo of retirement? How you have dispatched it to the petitioner, what is the procedure, what is the acknowledgement. And without filing all that, you can't file a memo of retirement like this. If
Your
you're
Lordship,
saying
we have
that,
handed over all
if
the
you
file
handed
to the
over, you have to
petitioner.
take a copy, you have to take the signature of that and file it before the court. Without that, the court will not accept your
That
retirement.
filed it, Your Lordship.
Where is it? The council undersigned craves leave of this court to retire from the captioned matter. The files stand duly dispatched. It is humbly prayed that the same may be taken on record. What is to be taken on record? No document. Already, what is the order last time? Have you seen the order?
On Lake State, we will produce the acknowledgement, Your
No, on
Lordship.
23/8/2025, passed an order already.
Yes, my Lordship.
A memo for retirement is filed by the counsel of the petitioner which do not contain any details on the counsel of the petitioner is not present. Till the court permits the counsel to retire from the case, it's a duty of the counsel to appear before the court. Have you not seen this order? By this time, you should have done what is to be done.
He had informed the
This
client
is
today, Your
matter-
Lordship.
On 10th of September, by the time.
No, not 10th, any day either before or after, not 10th.
What is your problem? They want to file the memo of retirement, not
My Lord,
for arguing
no,
the
what-
matter.
not-
Yes, so and so. And by the time the memo of retirement shall be filed, duly enclosing the necessary documents. Yes, delete from the caption dismissal. Yes, next.
Number for orders matter, say limit to Rashid Khan.
For the petitioner in this case, Madam.
Non-rectification of office objections raised on objection filed by party in person on 25/7/2025.
Your Honor, that has been rectified and I have been issued the Form C based on that.
Objections,
There was no objection on my application for party in person on 25th of
party
July.
in person. Objection is on the objections filed by you. Have you filed objections or not?
That was filed.
On that, there are objections.
That is,
So comply with it. The party in person shall comply with the objections raised on the objections filed by party in person within a week. List this matter immediately after that.
Your Honor, there are two other prayers that I would like to produce.
First of all, do that, we'll consider later. Yes, next. Once that is rectified, list the matter. Yes, 3.
Number 3.
What is the council submission?
Needful is done. Annexure L is the part of the annexure A. Annexure A is the impugned order.
Counsel for the petition has completed the office objection. On complaints of office objection, raise the following objection yet to be computed. Complete copy of annexure L to be filed. Remaining portion of the order is already submitted along with annexure
A, my lord.
in this writ petition. Where is annexure L? Page number?
Lordship, kindly see. My lord, page number 81. 81. 81 impugned order. Impugned order. Annexure A, Lordship, kindly see. Annexure A is also impugned order. Both are one and the same. My lord, the impugned order was typed on the order sheet. That's what some mistake. And this
Where is
matter may be
impugned
called.
order? Page number?
My lord,
Page number.
page number, my lord, 37, annexure A.
Then why do you want to file this paper?
My lord, this
Unnecessarily create
annexure L is
office
produced.
objection with regard to the complete copy of annexure L to be filed is overruled. Yes, please argue.
But this matter may be called along with the WP number 27-153 bar.
Along with
223.
so and so on Saturday, not a Saturday, on 3rd. Yes, next.
Bill number 4, hearing on interlocutory application, SB Total. They are registered for electronic.
Yes.
And for the petitioner,
Yes.
I may be permitted to file the bank statement as my lords has directed to file the bank statement of the petitioner.
If I remember, I have not directed you to file. I said, why you have not filed?
Yes, my lords, you lordships directed.
Lordship directed, no? Copy could
Has he given a copy of it to you?
not yet given.
You should have given it by the time it comes.
I'll furnish now itself, my lords. That copy yesterday.
He has to go through that.
because there was leave, my lords, that's the reason.
The petitioner shall
request you,
file,
Lordship.
don't take that, give her a copy. The petitioner shall file the memo before the registry. List this matter on,
9th, my lord, if it
on
is,
9th, 11th of September.
please, my lord.
Yes, next.
Number
But-
5. Number 5. Authorized V. Gunjal. Vardhaman V. Gunjal for petitioner, Ashish R. Agarwal.
Your Honor, I may be permitted to appear through video conferencing, Your Honor.
Yes.
I'm grateful.
What happened?
Your Honor, we have successfully settled the matter on 20th of August, Your Honor. Yes, Your Honor. And there is a settlement agreement we have entered into. And this same has been ordered for dissolution.
So I'll say, in the light of the settlement dated so and so, writ petition is disposed of.
Yes, Your Honor. Your Honor, there were 5 bank accounts which were there in the list of the settlements in the last point, Your Honor. The wife has, Your Honor, signed the documents and have submitted in the bank, Your Honor. But the bank is now telling the wife has to be present. But whereas she has already given her consent for the closure of
You
the joint
already
locker.
settled the matter, still you want to argue. Settlement
Your
is
Honor,
over.
Your Honor, I'm not arguing for the matter, Your Honor. If an express order may be given to the bank directing it to close the locker, Your Honor, because the wife has already.
Counsel, pass over. Pass over.
Then number
Yes.
6.
For the petitioner, my lords, in this petition, I am challenging the order of the trial court, where an ex parte order of a maintenance of sum of rupees 5,000
Yes,
is been ordered.
Where is party, Mrs. Ashish Agarwal?
Matter has been settled, my lord.
Your
No, no,
Honor.
he's saying something.
The
What
matter
he
has been
says is-
settled.
he says matter-
No,
one
it's
minute.
been recorded in the MC, my lord.
He says matter is settled. What he's saying is the locker that is there, which they want to close, what they're saying is they're seeking the presence of the wife to close the locker.
Not even.
Somebody assist him.
ಇವತ್ತು ಕೇಳ್ತಾ ಇಲ್ಲ.
No, what he says is, no, everything is settled. Now, for closing the locker, bank is insisting for the wife's presence. What he says on that?
Your Honor, this is the comment of the bank, wherein
Bank, today we are filing an affidavit that will be released back to us, my lords. That orders will be passed by the family court. We are filing that affidavit today because 3 days is a holiday.
What affidavit you are
No,
filing?
the 12,50,000 which he had deposited in the
Not about that. It is about the bank locker to be closed.
bank locker, we have no objection for closing, my
For
lord.
that, the bank is insisting for her presence.
Party, my lords.
In that case, what he's saying
I
is-
told my lord.
No. In that, what he is saying is, let there be a direction saying that, because both of them have agreed, the
Please, my
account
lord.
can be, the bank account
No.
can be closed in this
I
order. right?
am ready to send a registered letter to the bank because only for closing, if I want to go, I have to spend about 50,000 rupees.
I'm saying I'll record it in the order.
Your lordship may record in the order.
exactly.
It is, where is the settlement?
Very
Please.
grateful,
Where
Your
is
Honor.
The court has got that jurisdiction that can do it.
Where is that settlement? Have you filed?
The settlement memo, I have applied for certified copy. It's not received.
Settlement dated, please tell the court. Dated?
20,
Yes, Mr.
20th August, Your Honor.
20th?
20th of August, Your Honor.
20th of August,
2025.
2025. It is
Yes, sir.
submitted by both the councils that the disputes between the parties have been amicably settled and they have a joint memo. They have entered into a joint memo dated 20th August 2025 and the same is filed before the family court. In the light of the same, no further orders required to be passed in this writ petition. But however, it is submitted that they want to close the bank account, bank locker, but the bank authorities are for closing the same. They are insisting for the presence of the wife. When counsel appearing for the wife submits that that is in the joint name.
Yes, Your Honor. The locker is in the joint name.
What did you write?
Joint name, yes, my lord. It was a joint name.
Submits that as they are insisting, if they for closing the same, they are insisting the presence of the wife. Land counsel appearing for the wife submits that for the said purpose, if she has to go to Bombay, She has to pay an amount of rupees, at least she has to spend an amount of 50,000 for that. In these facts and circumstances, for the husband, the bank shall close as it is agreeable to the wife, the bank shall close the account, close the locker.
Your Honor. Number 150.
On the approach by Mr. Ashish Agarwal, the husband, accordingly disposed of.
Your Honor, the locker number kindly may be specified. Locker number 150.
Locker number 150 in which bank?
150 in Indian Overseas Bank. Indian Overseas Bank.
Indian Overseas Bank, place?
Sector 17. Vashi.
Sector 17, Mumbai.
Vashi. Vashi, Navi Mumbai. Vashi, Navi Mumbai.
Yes. All pending IAS are closed. Yes.
Very grateful. Much obliged.
You appeared before the mediation or?
Your Honor, I had appeared before the mediation.
It was before the mediation or the mediator?
Mediation report. The mediation, it was settled, my lord.
Bangalore mediation.
Yes, my lord. Fully
Yes,
passed.
Your Honor.
Cell number 6, open hearing.
Appearing for the petitioner, my lords. My lords, in this writ petition, I am challenging the ex parte interim order passed by the.
Why you are the ex parte?
My lords, before issuing the notice, they have filed an application for maintenance, my lords, by the wife. The court has passed a sum of rupees 5,000 monthly to be paid to the wife till disposal of the.
What is
IA.
your financial position? What
My
do
lords,
you do?
he is working with his in the shop of his father, my lords.
Even if we are taken like as a daily wage worker,
Please,
daily wage worker,
Please, my
at least you get 15 to 18,000.
my lords, in this case in hand, my lords, the wife has voluntarily deserted the petitioner, my lords. We had filed an restitution of conjugal rights petition also. There also she filed wakalat. She did not file any objection. And after that, my lords, even though an order was passed to come and join the petitioner, my lords, she did not join.
Is ordered.
Sorry, yes, it has been ordered, my lords. So, and there, my lords, after that, when she did not come, during the pendency of this 125 proceedings, my lords, I had filed a divorce also. But in that also, she did not turn up, and that has reached finality. She has already deserted. So, my lords, as per section 120.
Ordered or not?
Ordered, my lords. Final order has been passed on 9/4/2024. Divorce is also granted, my lords. Now, my lords, I only request.
Please come. Notice to the respondent, petition is permitted to take out, which is pending now?
For 125 proceedings, my lords.
Take out hand summons on the counsel appearing for the respondent for the trial.
Criminal miss 112 of.
File a memo to that effect by 22nd of September. If it is filed, list the matter immediately.
My lords, let there be a stay, my lords.
It is submitted by the, from 24, what are you doing?
My lords, that.
So that's not right. That is some interim measure. Now that the stage has gone. Yes, 7.
My lords,
Number 7.
only that.
7.
Much obliged.
Cell number 7,
Hello,
Anupama
appearing
Hegde
for the
petitioner.
respondent. My lord, the current status is, it's under negotiation. What we had done,
No, negotiation failed, my lord. As per my
no,
instruction.
my lord, it does not
He
fail.
is claiming the full custody of the child. My lord, actually what has happened, he deserted the mother and the child. And thereafter he clandestinely, during the festival of Deepavali, he took the custody of the child and did not return the child back.
So
And now the mother has filed both have filed the custody of the child,
lord.
and he filed a divorce petition, and I filed the restitution of conjugal rights. And my allegation is that he is having affair with a lady who is having 2 children, and his plan is to dump the custody of the child with that lady who cannot take care of 3 children. When the biological mother is present and he who is capable of taking care of her child. Therefore, I need my child's custody, and I am ready to give visitation right to the father. But in the other way, he is claiming the full custody and ready to give the.
Where the negotiations are going on?
My lord, we gave an offer in the month of June, July to them. They gave a counter offer.
Who is taking care of the negotiation? Advocate?
My lord, I'll just make my submissions. Last week, the opposite advocate came and gave a counter offer to us. So we are still yet to finalize on that. In fact, after discussions, we have pushed all the family cases, which is the MC, GWC and all those, to 18th of October just to accommodate these negotiations. Second thing is all the allegations which they're putting, we don't even know what they're even talking about. If they're filing something, that is fine.
Litigation center, these private negotiations are not.
My lord,
My
yesterday
lord,
itself,
my only
the
submission,
advocate appearing before the family court informed me that negotiation is not possible.
my lord, my only submission
Because
is
he is claiming
let
the-
them put a formal application or other thing stating that it's
Parties
failed.
shall appear before the
And
Bangalore
second-
Mediation Center on 10th of September. Yes.
My
Much
lord,
obliged.
the husband may kindly be directed to bring the child also. She
My
is
lord,
8 years.
my lord, we are following,
Girl child, my lord.
my lord,
Not with the father.
my lord, let me make my submissions, my lord.
My lord, the custody of the child is with the father. And she is infested with the lice, are full of her head.
My lord,
And
if I
she
can
is
make my submissions.
pulling her hair and there is a scratch on the head.
My lord, if I can make my submissions for 2 seconds, my lord. There was an order from the family court on IA-5 where she was given, visitation rights on a Sunday. And after that, this one,
Not passing any orders. Yes, yes.
much obliged, my lord.
Cell number 8.
No representation for dismissal on 15th, 16th of September.
Cell number 9.
I appear for the petitioner, my lord. I'm for the husband, my lord.
Yes.
There was an application, interim application, an interlocutory application which was filed by the wife, my lord, for interim maintenance of 5,000 rupees, which was granted, my lord, and we're challenging that right now. My lord, no asset and liability document was produced.
What is your income?
No asset and
I
liability.
said, what is your income?
That I'll have to.
You have to find out. This is matter of Tuesday. Yes, next.
My lord, date.
Tuesday.
Date.
Yes.
290. Cell number 10, urgent. Cell number 11. 11.
Petitioner, my lords.
Rajendra Kumar Sundar.
According to me, this matter is covered because the wife's petition challenging the order of the trial court, which is ordered perjury application.
Representing so and so to give fair opportunity to the petitioner, interim order or granted. No representation for the respondent.
They were appearing, my lords, because it's covered as per my
No, that is
submission.
true. We have
Please.
to give them an opportunity. Last time you were not there.
No, I was there online, and that is why it was.
This is the order I'm looking at. Sri Hari.
That is mine.
So and so
Me, my lords.
appears to video concedes time for a week.
Please.
Sri Ajay Lankan's respondent appears before this court physically to give fair opportunity to the petitioner to pursue list on 29/8. Interim order earlier granted is extended. Counsel for the respondent is present. No representation for the
Petitioner is present. I'm petitioner.
land counsel for the petition is present. No representation for the land counsel appearing for the respondent. List this matter finally on 16th of September on the day whether there is representation on behalf.
My lords.
Ready?
12.
Respond.
Sagar V.
Ready?
Shastri.
Ready?
My lords, let them conclude. My lords, the instructed counsel is before Delhi, my lords. My lords, the respondent's instructed counsel is before Aptel, my lords.
We can
Let them
commence
conclude,
this-
my lords.
I'll make my submissions, my lords.
16th.
Interim order, my lords.
Interim order earlier granted is extended.
My lords, if they're ready, pass over, it may be granted. It's a short matter.
Okay, come.
My lords, today it won't be
He
possible.
said what you
Today
heard,
is
what
not-
it is said. 16th, yes, next.
Interim order may come.
12. Sagar V. Shastri, for petitioner.
For the petitioner, lordship, this is husband's petition challenging the order on interim maintenance.
How much is
However,
granted?
your lordship, on the last occasion, there's an interim order, I have complied also. On the last occasion, I made a submission stating that the parties are deciding together and chalking out some settlement. However, they still do, under the process, I called them yesterday, they still want some time to come to a concrete settlement. If I'm given.
See, if that does nothing works out, they can review this petition. That's what I'm
I will argue on merits, your lordship. 1 week may be granted, I will seek some concrete submission.
He submitted that, what is the same, maybe last occasion also this must have been recorded. It is submitted that parties are living together and the council shall get instructions.
They're still living together.
It is submitted that council seeks further time to get instructions. Finally, list this matter on 11th, no further adjournments.
Obliged. There's an interim order, your lordship.
Interim order, look at it if it is there extend. Yes,
Obliged.
13,
13. Vijay Kumar K. C. Shankar Reddy.
Yes.
Petitioner, my lord.
Respondent.
The husband, my lord, petition filed. This is the challenging the order for interim order passed by the court below, my lord.
There is order.
Page 17. 17. The operative portion of the order, my lord, is page 20. Petitioner is directed to pay interim maintenance of 5,000 each to respondent and her children. Petitioner is ordered to
How
pay
many altogether?
3 members, my lord.
15,000 is ordered.
Yes, my lord.
What is your income?
My lord, my income is per day 500 rupees. I am a labor working in the garage.
So 5 into
So,
30.
13,500, 3 days holidays is there, 3 Sundays. Excluding that, my lord, my income 13,500.
Have you contested the matter?
Yes, my lord.
Let it please come to the.
Kindly look at reason portion, my lord.
Yes.
The page 18, para 4, may kindly look at, my lord. Para number 4, page number
Please
18.
read. Please read.
The petitioner being the husband has filed objection in the above IA denying the entire contention of admitting that marital relationship and paternity of the children. That the petitioner contends that it was the respondent used to raise issue stating that petitioner was not matched to the respondent and respondent was not interested to leading with the petitioner. Respondent did not like to lead life in the village. Hence,
All those things are not necessary. Come to para 6.
para 6 is the final portion. The respondent has filed the above IA seeking for maintenance herself and children. Respondent contends the petitioner has failed to neglect to maintain the respondent and her children. On the other hand, petitioner contends that respondent did not show the interest towards the marital life with the petitioner having deserted
Which
the matter.
court is this?
Contending that he has aged. Contending that he.
Civil Judge and JMFC Mallur.
Yes, he has aged parents and he is sustained
No
injury.
discussion about the financial capacity of the husband. No discussion about the statement of assets and liabilities.
The last date I have filed some of the additional documents before this honorable court.
Not about you. Court has to discuss.
As per judgment, my lord, both assets and liabilities.
In spite of repeated circulars issued, why they are not following, we don't know. Take this order also. Take it, give it to him. Please come. I'll set aside this order and remand the matter to the court.
Madam, one submission, madam. In the last date of on 12/8/2025, I have produced some additional document to show that the source of income.
What is the source of income?
Kindly see photographs produced last time. Madam.
Garage photographs.
From the photographs.
How can
From the photographs, how can the court come?
Kindly look into the photographs, my lord. He is a proprietor of the garage. I produced the photographs in that.
We'll ask them to file the statement of assets and liabilities and direct the court to dispose of the matter. Both of you file. You may get a much more good amount also than this 15,000.
Okay.
Agreed with the order passed in I number 2 in MC number 62 of 2023 dated 23/4/2024, whereby the court had granted 15,000 to the 3 petitioners. The husband is before this court. The counsel appearing for the husband submits that the husband is a daily wage worker and his monthly income is 13,500. The court, without considering any of the aspects, has granted the maintenance. It is submitted that as per the judgment of the apex court in Rajesh versus Neha, the court has not the statement of assets and liabilities were not called for, and the statement of assets and liabilities were not filed. And without considering the financial capacity of the husband, the court cannot grant 15,000 amount. Land counsel submits that the order needs to be set aside. Land counsel appearing for the respondent submits that he is a proprietor, he is having a garage and is earning income, and he has filed certain documents before this court. And the amount that is granted is a meager amount, and there no interference is called for. Next, having other counsels on either side, peruse the material on record. The Honorable Apex Court in Rajesh versus Neha has laid a comprehensive guidelines in cases of this maintenance. But unfortunately, in spite of repeated orders on the judicial side and also instructions on the administrative side, this court is coming across the case orders where where the courts are not adhering to the law laid down by the apex court. This court has perused the order. In the order, absolutely there is no discussion about the husband's income. Maintenance will not be granted basing on the requirement of the wife, but also basing on the financial capacity of the husband. Without ascertaining the same, the court cannot just like that pass an order. In these circumstances, the order impugned needs to be set aside, and the parties shall file their respective statement of assets and liabilities within 10 days from the date of receipt of the copy of the order, and without further notice, the parties shall appear before the court on 16th of September, and within 2 months from the date of the from the receipt of the copy of the order, the court shall pass appropriate orders. The registrar, the registrar judicial, the registrar general is directed to issue a circular to all, apart from the family court judges, to all other senior civil judges who are dealing with the family courts, that they have to adhere to the law laid down by the apex court in
Ranjesh case.
Rajesh versus Neha.
Yes.
In the judgment of the apex court in Rajesh versus Neha. Accordingly, so and so, the court is passing the following order. The order dated so and so passed by so and so is set aside. Matter is demanded back, and all those 1, 2, 3. This condition.
Till then, let him continue pay maintenance.
How much you're paying?
Whatever already still this.
7,000 was.
What is the impugned in interim order in this?
But interim order is 7,000. Already paid more than that. 10,000, 15,000 is with them.
Till the application is considered, the petitioner shall continue to pay 7,000 to the respondent, which is subject to the further orders to be passed by the court. Yes.
Great.
14.
Cell number 14. Sunil S. Narayan for petitioner. K.
Petition.
Prasad.
Last date, your lordship had sought that to file any memo, whether an order has been complied. I got the update from the.
By 29/8/2025, a memo shall be filed with regard to the compliance of interim order dated, and by the day if order is not complied with, the stay granted by this court stands vacated without further reference to the court.
That is what.
Where is the memo?
Well, memo is not. I will submit. Memo has not been filed because only 25,000 was paid once an order was passed. Thereafterwards, it was I have been instructed that the petitioner went with amount since the wife did not appear.
Give it to him now, if that is the bona fide.
My only submission. He came with money since she was not present. The council, the trial court did not.
I cannot take the submissions of yours.
Matter is on 3rd, your lordship. Matter before trial court, 3rd of September. Matter is there.
Then we'll hear this and we'll dispose it off. Argue on merits.
The 3rd, the 3rd they will pay. What is that? What the
No. This is an IA order. We will hear the matter and dispose of. Where is the impugned order? Come to the impugned order. The court had granted 10,000
and
the applicant.
Yes.
Yes. Please read the reasoning part.
Reasoning part.
Come to paragraph 6.
Paragraph. Reason. It is specific claim of the applicant petitioner under the present IA that she has filed this petition seeking for divorce from the respondent. It is her grievance that though she is the legally wedded wife of the respondent, got him married in the 2010 and has led happy married life with him for a short period, but thereafter the respondent and his family members started irritating her mentally and physically. She has compelled her to seek divorce from the respondent. According to her allegations, even after the birth of the son, the respondent has not maintaining them by providing any financial assistance to them. It is her claim that since she has studied only up to the SSLC and she has now no avocation nor any source of income, she is in need of interim maintenance amount pending disposal of the petition. Per contra, these allegations of the applicant have been categorically refused by the respondent, who has though admitted his marital status with her and his paternity on regards to his son. Respondent has denied to have been ill-treated the applicant as alleged by her. On the other hand, it is the rival contention that she herself has left the matrimonial home
without any justifiable ground, and as such, she is disentitled to claim maintenance. He has further contended that since the applicant is having independent income by doing tailoring work under the name Chelva Ladies Stitch Wear, and also by getting income from her family business as a partner by running a juice shop. However, the fact that presently the applicant with her minor son is staying away from the respondent has not specifically denied by him. His only contention is that she has voluntarily deserted with him without any valid reason. The disputed issue whether she has left the matrimonial home without any just cause or whether she has ill-treated by the respondent and his family members are all the aspects which cannot be gone into this pre-trial stage, since those issues required a detailed trial. It is further urged by the respondent that he himself has been paying school fees of his school.
Yes, what is your income?
Income, I am working as a
DTH.
DTH per installation.
1 lakh.
It has not been so. Kindly see para number 10 of the.
I have read that. I know
Though
you
the
have come
applicant
before
has
the
urged the
court.
monthly income respondent on that, but no substantial event, substantiating the fact
I
she
have
has
read
not.
it. I've read it. I'm asking you, what are your instructions? What is his income? Without saying that what wife says is wrong that's not correct. You have to tell the court what is your income. Pass over, please get your instructions from your client, or else we have to pass orders. Yes.
It may call on Monday.
Pass over. I'll pass orders by Monday. Yes.
Cell number 15. Cell number 15. Anand Gurappa Balloli for petitioner.
Please.
RB Sadashivappa.
Yes.
My lord, on the last stage of application, the interim
At the
order
request
is-
of non-conformance of the respondent, is this matter interim order is extended. Yes.
Actually,
Please come to the impugned order.
Yes, my lord. Impugned order, your lordship, last date, your lordship was suggested, and the taking care of the child is concerned, your lordship was directed to pay that. There is an interim order, 6,000 to the wife.
Let us see, because I don't remember everything.
Please. This is an interim order.
The
your lordship.
respondent is directed to pay interim maintenance of 6,000 per month to petitioner number 1.
Please.
And 12,000 per month. 6,000, and wife is working.
Wife is working. Yes, she's
So
admitted.
then I have suggested
And she's-
that
Yes.
wife is not entitled.
She is not entitled. Your
But
lordship was suggested.
as far as, and your income is?
My income is after deduction 46,000 is the school teacher.
Without, what is the gross income?
Gross income is the 65,640. After deduction 46,432.
46?
432.
432.
Into that, and
Then-
loans have taken.
Then what about, no. I
The
remember,
respond-
I asked you about the
wife.
Educational expenses
Yes,
of the child.
that is your lordship in a page number. In the impugned order. Your lordship, page number 21, my lord.
21.
23, sorry, 23, para number 13.
13, yes.
See, the learned accounts respond argue that petitioner number 1 is teacher in private school and she is earning good salary, and in fact, the petition number 1, her declaration income, she stated she is a private school teacher earning 12,000 per month. Of course, these aspects so and so. And your lordship, apart from that, she is getting coaching 150 students and she is earning 9,20,000 also per year. Consideration of these aspects. Your
However,
lordship
there
was
is
suggest-
no document to substantiate.
Let him complete.
Consideration
let him
of this,
complete,
considering by this aspect, your lordship was suggested to pay the fees for the child.
How much is the fees?
Yeah, your lordship, even that is also there in the.
Which class she is?
In para number, page number 22.
Which class she is?
She is PU.
Engineering first year, my lordships.
What is the fees?
3,000 as per the declaration
the
of.
fees?
My lordships, 1,59,000 every semester, my lordships. Every semester it comes to 1,50,000, my
The
lordships.
mother is able to bear all this expenditure.
That is why that is the problem, my lordships. See, she is getting a scholarship, my lordships. Half the amount is getting scholarship, my lordships. Now she has left
It's the amount that is paid by you.
me, my lordships. The entire amount is getting by me. I am paying, my lordships.
Say that she's getting scholarship. How much is the scholarship? Just
That I want to get the
please
records,
get
my lordships.
instructions. What we will do is in this matter, as far as the wife's maintenance is concerned, that will be set aside.
My lordships, take 1 minute.
To
ma'am.
understand what is the order.
My lordships, I want to clarify one thing, my lordships. See, was
Not here. If you give all these expressions to the court, writ petition is allowed. I'll pass the order later. Yes, next.
Cell number 16.
My lord, I'm appearing for respondent in this matter.
Yes.
16.
My lord, I'm appearing for the respondent. Request for a passover, my lord,
Yes,
at
password.
2:30.
Password. The 17.
Cell number 17.
Kindly pass over the matter.
Yes.
Cell number 18. 18
That's kind permission.
List number 3.
I got one phone call that my close death agide soon. So I want to go to. Kindly have it on Monday soon.
Which one is that?
Cell number
14 pass.
14. List the matter on Thursday.
Much.
Yes.
49. Cell number, list number 3. For order. Cell number 1
Is this
for order.
informed? Is this informed? 2 o'clock one. Yes, next.
Cell number, list number 3, cell number 1 for orders. Yes, sir.
Give that. The earlier matter that the Pradeep argued. No? On 23/8/2025, this court has passed an order on the memo of retirement filed by the learned counsel for the petitioner.
My lordship, appearing for petitioner, I filed a wakalat in the morning.
One.
One. There is a confusion. Serial number 1 or 2, exactly. M. Venkatesh.
M. Venkatesh.
M.
is one.
Venkatesh.
Your file wakalat.
Oh, file
What is-
wakalat.
It is submitted that so-and-so has instructions to file, so-and-so has filed wakalat in the morning.
Morning. Yes.
Morning, and office objections shall be complied with within a week, or else the petition shall stand dismissed without further reference to the court. He has to.
Cell number 2. This is one.
Office objections to be complied with. What is that? The counsel Srimati, the petitioners file a memo of retirement. In this, on 23/8/2025, this court has passed order on the memo filed by the learned counsel for the petitioner seeking to retire from the case. And this court has also observed that it is stated that the entire set of papers pertaining to the case, along with no objection wakalatnama, have been given to the petitioner. And she has also placed the entire entire material to show that the same is given to the petitioner. Hence, the advocate is permitted to retire. And this court has directed that the name of the party to be printed. Today also, the petitioner, after taking no objection from the earlier counsel, has not taken any steps nor filed wakalat before this court. Hence, the petition is dismissed for non-prosecution.
Cell number
Yes.
3. 3, let it be.
Regarding this matter,
Appearing for
I'm appearing for
respondent.
petitioner in 228. Let the matter is been settled between the parties. The respondent is before the court. Mediation is agreement is been already given. Only-
Where is that agreement? I think last time that agreement is not there.
Yes, no. Last time I have taken
Oh.
adjournment for the
When is
reason
it-
that
When is it settled?
it was settled on
37/2025, my lord.
Here it is.
Right. As per mediation, terms of mediation, my lord, the respondent has
There is counsel appearing for the
one submission.
petitioner and the respondent.
One submission. That the respondent is agreed to pay 1 lakh rupees. Anyhow, the respondent is having jewels allowed, so she is having jewels and respondent.
To that, let us see what is that.
Like 1 lakh,
So mediation.
1
The
lakh he has to pay,
petitioner
madam.
Husband has agreed to pay some more rupees, 1 lakh to the
That's-
respondent wife.
Yes, madam. That amount today he is paying. That's what I'm making submission.
He paid.
Now he is paying, madam.
Oh,
Please.
give it to him.
Yes, my lordship. Yeah.
You have given him, you should have counted it by this time, it should have happened. Pass over.
Yes.
Do whatever is supposed to be do, I'll record it in the afternoon.
Please, please.
Yes, next.
Please.
Number 4.
Great.
Cell number 4 hearing on IA.
Petition this matter, my lord. This
go ahead.
matter, the short point would be, my lord, whether the children's expense is to be paid or not, but MFA is filed, my lord. We heard after the MFA is disposed of, my lord.
MFA is pending,
It is
MFA
submitted
76/10.
MFA is pending. This is matter, we'll say in the month of January. This is matter in the month.
Or it may be referred to mediation center. Let us see whether mediation center.
It may be referred to mediation, I have not.
Both the parties submit that the matter may be referred to the mediation.
This matter to requires a senior mediation, my lords.
Then we'll say Sushila, where the parties
Because
will appear before
last time your lordship suggested,
Council, Mrs. Sushila.
because of her, my lord, we could bring some persuasion in that matter. Idrallu ade tara ide. So if that senior mediator is there, my lord, I think,
But anyhow, that party in person asking for.
I leave it to the court,
settlement is,
but
you appear
she
before
had
the-
about 5 to 6 sittings finally. Even at 6 o'clock in the morning, we had sittings, my lord. Court work it was.
Sushila, yes. P. Sushil, senior advocate. Yes, next. No, they will go and.
Please.
Yes.
Cell
fine.
number 5.
List the matter after the mediation report is placed before the court.
Cell number 5. Ranjan Kumar K.
I represent the respondent blood. For the child, 20,000 was granted by the trial court. This honorable court on 4/3/25 directed the petitioner to deposit 50% of the arrears and to continue to pay 50% of the maintenance granted. So far, nothing has been paid.
The counsel for the respondent is present. No representation on behalf of the petitioner. List this matter for dismissal on 10th of September.
Cell number 6. Admission. Satish HK for petitioner.
I am for the
Namita Heman.
petitioner in this case, my lord. This is our husband's petition for reduction of maintenance amount, my lord. Wife and 3 children have filed the petition at section 125 CRPC, my lord,
Where is the impugned order?
at page number 14, my lord. Family court has passed the sum of rupees 7.
Both have questioned this order.
Yes,
Yes, ma'am.
we have sought for enhancement, my lords.
My lord, for the totally family court has added for 19,000, my lord. For the wife 7,000 and 4,000 each to the 3 children, my lord.
7,000 to?
Wife.
4,000 to the wife, 4,000 each.
4,000 each to the children, my lord. 3 children, my lord.
That's 12,000.
19,000, totally 19,000.
Total 19,000. You said 4 into 3.
4 into 3, my lord. 12 plus 7, 19,000, my lord. Totally.
What is your income?
My lord, he is working as a lorry driver and earning a sum of rupees 15,000, my lord. My lord, in this case, my lord, second respondent is the first son, my lord, Abdul Rahim. He is residing with the petitioner. He is present before the court.
Let us look at the cost item.
Cost title is,
To understand who is the respondent.
yes, my lord, in this case, I am filing a affidavit to show that the first respondent is residing, second respondent, first son is residing with the petitioner and the father, my lord. along
What
with
is his
father.
name?
Abdul Rahim.
Abdul Rahim. He's
Rahim,
shown
my
as age 13 years.
17 years, my lord. Now,
That's in 2020. He's residing with you.
with the father, my lord. Since
And
from
what
the
about the
beginning,
other two?
other two is residing with the mother, my lord. My lord, in the affidavit, I have stated, my lord, mother is doing money laundering business and she has the capacity and earning, my lord. Even she has taken the house for on a lump sum basis, wherein she
Evidence
has
for
not
that?
paid the rent, my lord.
Any evidence for that?
No evidence, my lord, but there
Cannot
is a evidence,
consider.
my lord.
We can't consider
For
all
that reason, I have filed the affidavit, my
All
lord.
oral submissions can't be considered.
My lord,
So,
and further, my lord, wife has recently purchased the Maruti Omni, my lord. I have furnished the RC book, B extract, my lord, along with the affidavit, my lord. It clearly shows that wife has the capacity and means to earn, my lord.
I'm sorry, I will deny, my lords. Lords, all these allegations, lords, the first time they are making before this court, my lords. They were not urged anything before the trial court, my lords. My lords, kindly see, my lords, you were at the intervention of this court, not your lordship. Not both the parties not sat together. Not she has not offered to come back. Not my client not immediately agreed. Not since she has no means, Lord, she immediately agreed. And she said, you take me anyway, I will come.
he said, my lords, he has, my lords, seen a house. My lords, I said, my lords, I'm ready to go. My lords, till today, my lords, after 1 month, my lords, he is not, my lords, responding my calls, not, my lords, agreeable to take her back. My lords, if she has means, my lord, she would not have done all this, my lords.
Why is?
My
My
lord,
lords, it is, my lords,
What about?
petitioner husband has searched for the house, my lord. Even for that,
Oh, no,
wife
I'm
has
ready,
not
my
come
lords.
forward, my lord. Wife has not come forward.
Because house, you didn't get the house, they're
Yes,
not
he-
joining.
My lord, now she is
Is it a
residing
big-
in
is
a
it a big
mortgage house, my
issue?
lord. That is the reason she has not
So
come.
if both of them want to stay together,
But-
why are you pursuing it?
Lords, what I suggested, my lords, lords, anyhow, I'm there in, lords, in a rented house, in a leased house. My mother, lords, my brother, lords, has given me, lords, about sum of rupees, 3 lakh rupees. Lords, for which, lords, I have taken a house on lease.
Then why can't?
But
Lords,
for
he
that
can
house, he
save
is
the
not
rent, my lords.
interested, my lord.
Lords, he can save the
Petitioner
rent.
husband is not interested in go there, that house. my
All
lord.
right, I will go with him.
Barely
If he is
better
not
house.
willing to come with
Then
me.
they look out for a house. What is the problem? Talk to him. Pass over.
Pass on.
Cell number 7. Purushottam H.E. 7.
I appear for the respondent. But as per the
Seven.
interim order, my lord, that
Hmm.
interim order, they paid, I have filed a memo.
Hmm.
They paid about 20,000 rupees and thereafter they have not paid that
How
I have
much is
furnished.
outstanding now?
The interim, the outstanding, my lord, that in the interim order, it is only directing to pay 3,000 and 2,000 from the
5,000.
order, 5,000. But with regard to the arrears, my lord, there is no specific direction.
This order.
That the order is dated,
Generally, I pass that order.
no, this is passed by the coordinate bench.
Then we'll hear this matter itself.
Please, my lord.
No representation for the petitioner. List this matter for dismissal on 1st of September.
Oblast.
Cell number 8. Final hearing. Usha Lingaraju.
The petitioners not produced to show that the amount is deposited.
Give that. Give the file.
Comply the order of the sound court.
Give the file. This is matter on 29/8. The registry that to call the teacher and have them out of this. And this one is proposed. You should have made it first to the teacher. Says that he will register, so look into this. Just like that. No representation for the petitioner. Learned counsel for the respondent submits that the order of the court is not, interim order is not complied with.
Not complied.
Is not complied with. List this matter for dismissal. This also on first.
Cell number 7.
Date.
7, not
Please.
7.
Cell number 9.
Yes.
Mamata Shetty.
This also for dismissal on the same day. Counsel for the respondent is present. You're for the respondent or petitioner?
Respondent, ma'am.
Respondent is present. No representation for the
They have to,
petitioner. For dismissal.
she has to perform the marriage of the daughter.
That's why on first for dismissal.
Please.
Cell number 10. 10. Venkata Ramanappa.
No representation for dismissal, same on first. Any passwords?
Yes, ma'am. There are so many passwords.
What list 5?
5. List number 5.
List this matter after service of notice in respect of R2.
Cell number 2. B.S. Umesh.
Yes, B.S. Umesh. Yes, Mr. Umesh.
My lord, connected matter is notices to go, my lord.
Not notice. They're seeking for release of the amount.
Yes, my lord, it was heard because my lord, the driver himself is the brother, my lord, elder brother. That is why, my lord, the amount was not released. The motorcycle is by the. Please, no.
What notice?
R1.
The 2.1 notice.
Cross-objection notice.
For 2.1 notice to respondent number 1.
Please.
Shall pay the process within a week, or is the petition shall stand dismissed. Any passwords?
Passover, sir. Passover matters. List number 1. Serial number 5.
Or is qualitative?
Your Honor.
Ask that lady to come in the afternoon. Ask the advocate to come. You know her. Ask her to come. Yes.
Plus list number 2, serial number 17, my lords. We have challenged, I'm appearing for the petitioner wife. Challenge.
What happened to that?
Well, it's one humble, they have not followed Rajneesh versus Neha affidavit of this one as
No,
a.
what happened? It is already called. Entire
No,
list
it is just passed over.
We will take it up in the afternoon.
After, much.
Your Honor, my serial number 2 was, you told that there was an objection to the objection I filed on 25th of July. So I checked the record. I have not filed any objection on 25th of July.
Call it in the afternoon. That's part of, call it afternoon.
Yeah. Serial number
We'll
2.
see in
list
the
two.
afternoon.
List 2, serial 2. What I say number? Yeah.
Number 3.
Serial number 2 alla.
List. Madam, list.
Pass over. Pass over to ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಸರ್.
List number 3 call ಮಾಡಿದ್ರಾ? List number 3.
An objection filed by party in
number
person
18
respondent on 25/7/25 ಅಂತಿದೆ. ಆ ಫೈಲ್ ನೋಡು. Serial number 17 pass over ಅಲ್ವಾ? 16 pass over.
2 ಕೊಡಿ ಮೇಡಮ್.
ಒಂದು ನಿಮಿಷ ಇರು. ಇದು ಯಾವ್ದಿದು 6. ಒಂದು ನಿಮಿಷ ಇರಿ ಸರ್.
ಇದೊಂದು ನಾಳೆ ಡೇಟ್
16, 17. Sir. After that, I will call 1 second because you told that you are not filed that. Yes, yes.
Madam.
Yes, yes.
Serial number 8.
ಅಲ್ವಾ? ನನ್ನ
Court officer? Court officer? Court officer? Court officer? Court officer? Younger brother, ಯಾವನು ಇವನು ಕ್ಲೈಮೆಂಟ್ ಯಾರು? ಇಲ್ಲೂ ರವಿ, ಯಂಗರ್ ಬ್ರದರು ರವಿನಾ? ಪಿಟಿಷನರ್ ಕೂಡ ರವಿ, ಯಂಗರ್ ಬ್ರದರು ರವಿ.
ಅಲ್ಲ
Court officer? Court officer? Madam? Court officer? Madam? Court hall ಅಲ್ಲಿ ಯಾರಿಲ್ವಾ? Court officer? 238 ಆಯ್ತು ಯಾರಿಲ್ವಾ? ಅದು ಮುಗೀತು.
ನನ್ನ ಪೇರ್ ಹೆಸರು
ಒಂದು ಕೇಸು ಅಟೆಂಡ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಎಲ್ಲ ಹೆಂಗೋ ಕಾಯ್ಕೊಂಡು ಕೂತಿರೋದು, ಕೇಸ್ ಬರೋದಕ್ಕೆ ಏನೋ ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗಿರುತ್ತೆ.
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರು 11 ಏನಾಯ್ತು? 11
ಪಾಸ್ ಓವರ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಪಾಸ್ ಓವರಾ?
ಹೌದು.
12 12
12 ಪಾಸ್ ಓವರ್.
ಓ ಗಾಡ್, ಅವಾಗೇ ಗೊತ್ತಾಗಿದ್ರೆ ನಮ್ಗೆ ಇದನ್ನ ಆಗ್ತಾ ಇದೆ ಅಂತ. ದಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 20
ಹಾ?
serial number 20.
20 ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಡಿಸೆಂಬರ್ಗೆ.
ಸರಿ, ಇದು ಸೀರಿಯಲ್ 11 and 12 ಕೊಡೋಣ.
ಯಾವ ಕೋರ್ಟು ಸರ್?
18.
11 and 12.
All this number to refer to local alarm. Morning 10:30 ಗೆ ಆರ್ಡರ್ ಕೊಡುತ್ತೆ. Referring to local alarm ಕಾಮನ್ ಆನ್
ಇದೆ.
ಖಂಡಿತ ಇದೆ ಕಣವ. ಅದಕ್ಕೆ ಇವ್ರಿಗೆ ರಜಾ ಬೇಕಂತ. ನೀನೇ ರಜಾ ಹಾಕೊಂಡು ಮೈಸೂರಲ್ಲಿ ಸೇರ್ಕೊಂಡ್ಬಿಡು. ರೇವತಿನ ನಿಮ್ಮ ಹೆಸರು? ರೋಹಿಣಿ. ನಾನು ಆಚೆ ಅಂತ ಅವಳು ಯಾರು ರಾಗಿಣಿ ಅಂತ.
ಅವ್ರು ಆರನೇ ಅಂದ್ರೆ ಯಾರು? Yes, pass over.
Pass over matters. List number 1, serial number 5, Chet and DT. For petitioner
List number 1.
number 5.
She is there that you are talking about morning. Have you informed her?
Memo. That memo today, after that 20 meet, posted it to the registrar. Now I verify it and I told them.
Then if it is verified, if it is complied with, when is it complied?
Oh, she's telling the test.
Now I had talked with them, they say now it is gone to the board.
No, when have you complied the office objection?
21st.
No, ask the registrar judicial from 21st till today, why a matter which is complied with the office objections has not reached and why it is not posted before the court.
I myself had gone and complied on 21st. So in fact, after all
Take
the-
that number
That memo is
and
with
give
me
it to the
only.
registrar judicial. Yes. Yes. This is which one you are called now?
Serial number 5. List 1, serial number 5.
Why it is passed over in the morning?
That is because.
Give that. List this matter for dismissal tomorrow. In spite of asking for repeated adjournments, stating that the file is not available, yesterday same submission was made. Today also in the morning, same submission is made and the matter is passed over. When the matter is called, no representation. This is an MFA of the year 2020. In this, so far notice is not issued. At the stage of objections, when the petition is dismissed, IA number 1 of 23 is filed to condone the delay of 51 days. And IA number 2 of 23 is filed to recall the order dated 27/3/2023. At least from the last 5-6 occasions, there is no representation on behalf of the appellant. List this matter tomorrow for dismissal. Yes.
Serial number 11. Serial number
My lord, I
11.
am for the appellant, my lord.
Yes.
My lord, in this case, my lord, records may be called for, my lord. We have produced the number exhibit R1 to R14. That clearly shows that there is no negligence on the part of the BMTC.
Is
My
it
lord, the
required?
CCTV and photographs are all there, my lord.
Yes, TCR is required.
Yes, my lord.
Is it there?
PCR is not there.
It's not called. Is it required?
Required, very much required.
Can understand. Admit, call for the TCR. List this matter immediately after the TCR is called.
In the
After the
connected
TCR is
appeal
received.
delay.
Date. List this matter on 23rd. This is matter on 23rd. The registry shall ensure that the TCR is there on record by the time. Yes.
In the connected appeal, there is delay of 184 days. IA 1 of 21.
Without any interest,
Item
my
number
lord.
184 in 11.1, 184 on condition. Yes.
Serial number 12. MV Maheshwarappa.
Yes. On what ground the company is before the court?
My lord, can it be called next week, my lord?
Why?
You have denied the very involvement of the vehicle in the accident.
So you can argue today also. When the matters are called, Mr. Kumar, you won't be there.
My lord, one submission. Now the in serial quotal number 5, my lord, next matter is mine, my lord. That's fine, my lord. Please, my lord.
Then I will do one thing. I will hear his appeal and enhance the compensation, and your appeal I will hear later.
Then kindly pass over, my lord. I will finish for quotal number 5 and
So tomorrow morning in the matter called, no representation.
my lord, I was very
Mrs.
much
Matter,
available, my lord. Very much
Mrs. Matter,
available, my lord.
on 9, no further adjournments will be granted.
Date, my lord.
Next
Date,
matter.
Date, my lord.
999, sir.
Much obliged, my lord.
List number 2, serial number 2. List number 2, serial number 2. That is.
What is this? Rashid Khan. Give this one. Oh, yes. Oh.
He has filed some objections. He enclosed the submissions. Form C, Form A, he has to put in Form C.
Then nothing is required. Yes, office objections or overruled. Yes.
Yes, Your Honor. So in this matter, the trial court order that the petitioner has wanted to impugn has been recently revised by the trial court, and that order is going to be released. It has already been ordered in the court. Copy is awaited. So we have already applied.
Order is passed.
No, that was order on the interim maintenance, which I had applied for review based on change of circumstances. And it had also appeared that that order.
How can you file a review? How can you file a writ petition?
No, I have not filed a petition. I'm a respondent.
Oh, you're the respondent.
Yeah. So that matter in the trial court, that order has already been revised based on change of circumstances. And also it had emerged that that order was obtained by some fraudulent means. So that also has been submitted in the trial court. And the honorable judge has said that that is also being reviewed. Order will be passed on that also.
Shall we take up this matter tomorrow?
Yes, Your Honor.
Not there for dismissal, I'll post it. Party in person is present, no representation.
Your Honor.
Where is this party in person is Party in person is present, no representation for the petitioner. This is matter for dismissal tomorrow.
Your Honor, in the morning you had also told me to pray the two things after this confusion is clarified. So the other two things were that this petition itself, it is a completely frivolous kind of a petition because
That I have to consider finally when the other side is there, not now. Come tomorrow.
Okay.
Even if other side is not there, I'll consider tomorrow. Yes.
Cell number 16. List 216.
Yes.
I'm appearing to the respondent, my lord.
Please use the mic. On the mic.
My lord, the respondent, the arguing counsel is in her way. She'll read.
They've been there in the morning when the matter is called, and
Yes.
otherwise matter would not be passed over.
Yes, my lord, I understand. She's in other court. She'll be coming shortly.
She'll come.
Yes, yes.
Can I have
She-
it some other day because I have to go to trial?
She'll reach anytime, my lord. Maybe
This is
passed over,
matter.
or it may be taken up tomorrow itself.
December 17th.
My
December
lord,
10th.
my lord, there is an urgency in this matter, my lord. Kindly, it may be taken tomorrow.
Both of it, urgency, Passover, again Passover will not.
No, there's a stay on MC proceedings,
Then
my lord.
why the council is not there in the morning?
She's
and the
held
evening?
up in the, she was held up in the other court. Right now also she's
Call after 10 minutes.
much obliged.
Number 17. Rajesh Rohra, for petitioner. Rajesh Kamaya.
Yes, the interim order. Please ask my petitioner who has filed for divorce.
Let's see the impugned order.
My lords, if I may just pass on these, my lords, this will be relevant. This is
Basically, my short point is that affidavit of assess the liability.
Where is that? Where is the order?
Yes. Page 30 of my petition. I tried with the applicant in the section 24 is partly allowed. This page 30 of my petition additionally. Petition is million of 25,000.
Now you're seeking enhancement.
Yes, that is only one of the points. But primary point is, my lord, this particular order has been passed without considering the assets liability statement of the husband because two assets and liability statements have been filed by him. Once when he filed incomplete. Then I complained. Then this honorable court took note of it and directed him to file incomplete. Then he filed the second one that is also incomplete and fraudulent. I only take your options to 2 to 3 points where comparing the.
If it is a fraudulent one, you can file an appropriate application before the court.
More than using fraudulent as incomplete, I may be kindly permitted only to point out 2 important points, madam. Kindly see page 165 of my writ petition, which is a part of his first assets and liabilities. page 165. Kindly see that para 7. On the top, brief description of jewelry, ornaments, and the details of transfer deeds is blank. Now kindly compare this to the second one he has filed at page 176 of my petition. 176.
So what did he write? Nothing has been written here.
Nothing has been written, so now he's filed one more after I complained. Kindly see page 176. He's filed one more assets and liability. He filed two assets and liability statement which are contradictory to each other. Kindly see page 176. Kindly see the handwritten portion. Executed a release deed to release the deponent's two-thirds share with respect to B104, marital loan, etc., in favor of his mother, Reshma Nagpal. The petitioner was thrown out of the house on 2/8/2018, and on 25/1/2019, he states that he has given his share to his mother of the marital home. Kindly see the first statement, he doesn't reveal this. Second statement, he reveals, does not enclose this topic. This is one point. This is also not much of an issue, my lord. Kindly see page 164 of the previous affidavit statement. 164. Page 164. There on para 7, my lord, whether the one is access to income tax 1 year prior to marriage, 1 year separation, it's blank. Now kindly compare this with page 175. Page 175. He says yes, 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 but he has not enclosed. So, direct fraud on the court when he is submitting the assets and liability statement.
And when he has not done it, why did you not object to it?
I did.
And why did you not come before the court?
Yes, my lord, we came. And
That's in the first. No, that's in the first round.
Yes.
Second round.
Also,
You should have filed an IA. You should have filed some application before the trial court.
Yes, ma'am. We will kindly see page 33 what the honorable judge asks. Page 33.
Which court is this?
In the family court only first when I pointed out, and the family court took cognizance of the same.
I said which court is which first edition of principal law.
First edition. Page 33. Respondent counsel is hereby directed to complain the honorable Supreme Court. He filed the affidavit. My lord, since then, what has happened is continuously, even there are areas of 6,75,000 as on date. He is absolutely lying before this honorable court, and when I have approached this honorable court, my lord, I've been waiting for the opportunity argument by only consistency. He may be directed to produce his income tax returns as per the honorable Supreme Court direction. His 460, what is his salary?
No, we will not do anything. I will not send it back again.
Yes.
Subject to what she says. No, subject to what she says.
Yes.
I will take an adverse influence.
Lords, I have
and
one
I will,
submission.
I will grant 1 minute. I will grant 1 lakh.
My lords, I have one submission. I need only 2 minutes of indulgence of my lords. My lords, this is the entire statement this is the entire assets and liabilities filed by the petitioner wife and the husband, my lords, before the court. My lords, may kindly
Have you
see
filed
this
income
is-
tax returns?
Please, my lords, everything is here. Everything is here, including hers. I need
Is
only.
it a certified copy?
My lords, this is not even, it is marked, it is listed for evidence for the last 1.5 years, my lords. Apart from filing the affidavit evidence, there is not a single document is marked. Even today, the matter was before the court. Every time the court is directing them to mark the documents, my lords, that is not done. This is their own, my lords, their own documents. This is the wife's Here is the copy.
No, but there
My lords,
can't
this
be
is
any.
the wife's petition for.
No, she
divorce.
says you have not filed.
They have given us a copy in the court.
My lords, this is. My lords, let me complete, my lords.
Income tax acknowledgement first page has been given. Whole return is missing, not even the salary slip. My lord, I have it here, and I'm stating on affidavit before this honorable court. The lordship of kindly call for LCR and perfect page.
My lords, I need only 2 minutes, my lords.
The registered judicial is directed to call for the LCR.
Please, my lords. My lords, I need only 2 minutes also, my lords. Let the LCRs come. Please, my lords. My lords, as on today, 5,15,000 has been paid.
By Tuesday, list this matter, not by Wednesday, list this matter on, by 4th, list the matter on 9th.
Please, my lords.
File it in the registry.
I'll file it in the registry, my lords.
No, keep it, not listen, keep it. the statement of assets and liabilities filed before the trial court or placed before this court by way of a memo by the counsel appearing for the, both parties, by the learned counsel appearing for the respondent husband. The same is taken on record. Yes.
Serial, list number 3, serial number 3. Latif B. Srinivas GA.
Huh? Please take it. Why the party is not here? Huh? Can you give it to him? Give it to the council. I'll record that. Give it to him. I'll record that the council. Take his name also. Then what are the other? Let's see this. Come to that. Where is that memorandum? Next, 1 lakh rupees. Also has no objection for the respondent wife to retain the gold and valuables. Both parties have been living separately for fairly considerable length of time. On the basis of talaq announced earlier, however, to have clarity in the matter, wife has also executed a kulanama. So and so, both the parties state that apart from the above, they do not have any claim against each other in respect of alimony, either present, past, or future, as also in respect of the properties held by each of them, either in the present. The respondent wife agrees and undertakes to cooperate with the petitioner husband-in-laws, closing the TC number 265 of 2015. Both parties state that they will not interfere with each other in future. Both the parties appeared before the Karnataka Mediation Center, and both of them have entered into a settlement. As per the settlement, the husband has agreed to pay an amount of rupees 1 lakh to the wife, and the wife has agreed to cooperate for quashing of the complaint along with the other conditions. An amount of rupees 1 lakh is handed over by the learned counsel for the husband to the learned counsel appearing for the learned counsel, Mr. Mohammed Kaleem, representing Mr. Latif B.
Srinivas.
You appear, what is, Latif B, representing Latif B, and is handed over to him before this court. Considering the joint settlement, joint memo that is filed, the RPFC is disposed of, and the copy of the joint memo shall be annexed to the order by the registry. Accordingly, both the petitions. What is that? All of that will be part of it. So, RPFC 25 of 2025 is filed by the wife seeking enhancement of the compensation, and RPFC 228 of 2024 is filed by the husband questioning the quantum of maintenance. It should be the starting order starting, and both the petitions, in the light of the joint memo dated so and so, both the petitions are disposed of. All of them, I said, apart from other conditions, what are relevant is two, and it will be annexed to the order. That is there in the order. Yes. Next.
Serial number 16, 6 in third list.
6. What he says? It is submitted that the wife is ready to join the husband, and the husband is ready to take back the wife.
Only condition is, Willard, the wife has placed the condition to for separate house.
The condition of the wife for reunion is that he should take a separate home. The party who is present before the court submits that he is making all his efforts, and within 10 days he'll secure a place, he will secure a house for them to live jointly. List this matter on 18th of September.
Great.
Yes, next.
So serial number 16, which number 2, serial number 16?
This number 2.
Which number 2, serial number 16? Pass over for 10 minutes.
Sincere apologies, my lords. I got stuck.
Yes.
Sincere apologies.
Yes, yes.
Sorry, my lord, I have, this is the petition challenging the IA.
Where is the impugned order?
Lord, the impugned order is in page number, it's from page number 10, my lord. The operational portion starts from page number 13, my lord. Lord, I had asked for an entry maintenance and the page number 13 onwards.
Filed with the respondent is rejected. Where is, or if I read from the reasoning part?
My lord?
Read from the reasoning part.
The marriage,
Seven.
para number 7, marriage petitioner and respondent is undisputed fact. Respondent in her affidavit stated that she requires 39,000 per month towards shelter, food, clothing and medicine, and she has no source of income. Respondent filed affidavit regarding assets and liabilities, and her qualification is MBA, and her monthly expenses is shown as 5,000 per month. She is mentioned personal loan of 7,60,000 and she is paying EMI 16,430 EMI, which was marriage expenses, and also mentioned rupees 2 lakh loan for marriage expenses. She has also mentioned property in her name gifted by her father. The petitioner in his affidavit shows his qualification as BCom graduate, and his monthly income is mentioned as rupees 12,000 per month and rupees 7,500 per month for transportation, and insurance premium is rupees 3,665 and EMI hand loan rupees 15,000 per
Salary
month.
is 35,000.
My lord, my salary is 35,000.
What salary is?
My lord, he has, his salary is 36,000 rupees.
So why
Plus,
he should give
he is
you
also having monthly income of rentals, my lord,
Then
around
what is the
20,000.
material for that?
My lord, in his own assets and liabilities, he is very clearly told, my lord, in their objections, they have not produced his assets and liabilities. May I produce that before the honorable court, my lord?
Produce it. Take that.
It's his assets and liabilities, my lord. He himself has told that copy your assets and liabilities.
Where is it?
Lord, it's in page number 3, rental income of monthly.
No, according to you, you require 36,000, you are earning 35,000 already.
My lord, yes, the expenses I have asked is, my lord, because I am still paying EMI for my marriage expenses which I had taken, my lord, and subsequently both EMI and the hand loan which I taken, and subsequent only I am asking, I am the only sole earning member. I have 2 old parents. I am also taking care of them, my lord.
Your husband will not take care of your
No,
parents.
my parents, he need not, but that is also part of my expense, because of which
Please show that he will not.
35,000, I am not able to take care of all those, my lord. That is why I had filed it.
Please show.
In page-
Where is that? He said, what is the income?
My lord, it is in page number 3, rental income of mother rupees 12,000 is shown, my lord. It is not rental.
We'll take it that your income is 35.
Yes, ma'am.
His income is 36 plus 12. 6 to 8, 48,000. So if he is getting 48,000, why should he pay maintenance to you when you are getting 35,000?
My lord, here, he also has other properties which is also given for rent. However, that was not displayed in his assets and liabilities, my lord.
Court
In
was
that
right in
particular
not
case.
granting.
My lord, at least some amount, my lord, not much, because,
no,
my
that's
lord, in
not
this
the- that's-
particular case, she is literally struggling financially also, my lord, because she has whatever money she gets, because of him, he sent her out of the house, because of which few days she was staying with her parents, my lord. Subsequently, she was forced to take a house for rent, my lord, because of her old parents and his there are a lot of people in that her house also. So she was also moved out and taken a house for rent also, my lord, with all these expenses. And it was because of his fault, my lord. She was staying in the matrimonial house itself, and he pushed her out of the house, my lord. That is the only reason we filed for interim maintenance. At least some amount will really help her, my lord. It is not that we are asking. I don't want 39,000 also, my lord, but some amount if it's given.
According to you, he is earning 36. He should give you 39. What he will
No,
do?
my lord.
Why did you ask them?
My lord, we did not know. After we filed this application only, they filed assets
How
and
many days
liabilities.
you were-
But however, my lord,
How
while
many days you
my
were
lord,
there with him?
yes, my lord, while I was there for around 9 months, I was with him, my lord. But during that time, he was doing business and he was also earning huge rent also, my lord. And he was also working. So he had income, sufficient incomes. It was not that he is not having income. And in his assets and liabilities, he is not given those income details at all, my lord. This we had also raised
My
this
lords, my-
concern before the trial court, my lord.
I have only two submissions, my lords. My lords has kindly, specifically, my lords, I'm just relying on few citations in light of this.
Required all sides.
My lords, section 24 application has been belatedly filed, my lords, after 4.5 years of the MC petition having been invoked by the petitioner husband. My lords, that is the respondent herein. My lords, after the filing of it, section 24 specifically says what is the purpose of it. My lords, there are multiple judgments. Interim maintenance has to be,
So we don't have to
please,
go-
my lords, I
Apart
understand.
from legal submissions, any factual submissions?
My lords,
please
factual submissions, and it may be recorded. My lords, one is that the petitioner herein, her wife herself left the house and went, my lords. Now, after which the husband has filed the MC petition. Belatedly, my lords, when the matter was posted for respondent evidence, is when only to detract this, the proceedings, MC proceedings, my lords, an application under section 24 was filed. My lords, in the affidavit, though her interim salary is being shown as 35,000, my lords. At that point itself, she was earning around 45,000, which I've stated in my objections also. In addition to that, my lords, today I understand that her salary is around 1 lakh rupees. My lords, that may be also, she may be directed to produce her salary slips. In fact, my lords, she's far more educated than me. That is the husband, my lords. In addition to that, my lords, there is a
Learned counsel for the, it is submitted with the learned counsel responding with the petitioner's present salary is 1 lakh. The petitioner shall place before this court the latest salary slip.
My lord, similar with the respondent also, my lord, all his incomes and
My
all
lords,
his latest bank
in-
statement.
my
He has
lords,
a number of
latest-
accounts, my lord,
My lords,
all those may.
Salary slip shall be placed before the court. Yes, list this matter on 15th of September.
my lords, any date next week itself, my lords, because the MC petitions unnecessarily has been.
Why there is a stay in this?
Yes, my lords.
Should there be a
My lords, in
My lord,
fact,
the stay
matter was
was
at fag end.
This is the interim stay that is granted by this court.
My lord, I
Is
may I
vacated.
submit,
No,
my
no,
lord, no,
no.
my lord.
Why should for
no, the submission, my lord, why we had asked for the interim prayer was, my
Then
lord.
I'll pass
because-
orders now with
Yes,
the-
my lords,
My
my
lord,
lords, orders may be kindly passed, my lords.
My lord, the only reason for asking interim prayer, my lord, because the respondent literally
proceedings,
threatened the
please.
petitioner specifically
Lords,
telling,
it
I
is
will not
posted
even
for
give you 1 rupee as
Respondent
maintenance,
evidence
my
is
lord.
already done. It is posted
My
for
lord,
cross-examination of
And
respondent, my lord.
they telling that I am earning 1 lakh rupees is
With
not
the
true, my lord.
award, agreed with the order passed in I number 5 in MC number 373 of 2020 dated, what is the date? 19/4?
My lord, the marriage date was 19/4/2023.
19/4. So from that date, the suit is stayed.
Stayed,
The
my
MC
lords.
is stayed.
No, my lord, the
Proceedings have
MC's
been stayed.
proceedings
Yes.
was stayed subsequently after we got came to
19/4/2023, whereby the court had rejected the application filed by the wife seeking maintenance. The MC is filed in the year 2020. IA number 5 is filed in the year?
My lords, 2022.
In
No,
the
my
year?
23, my
The
lord.
IA is filed in the year 2023.
23.
Maintenance of 39,000 per month. Admittedly, the income of the wife is 35,000 and the income of the husband is 36,000.
My lord, not 36, sorry, my, it is 38 in his own assets and liabilities.
38,000, and
He
according to
said
the wife, he is having other landed properties and she has taken loans and she has several expenses. As
She-
such, she requires the amount.
My lords,
Court had rejected the application with the order impugned, considering the income of both the parties and considering the fact that both had their own liabilities for payment of personal loans. Hence, the court felt that the respondent employee and capable to earn for herself, the wife is capable and to earn for herself and also had property gifted by her father, and therefore she is not entitled for maintenance. Next, counsel appearing for the petitioner wife submits that the wife is having for the purpose of her marriage, she has taken the loan. Substantial amount of the salary is going towards for the payment of loan amount, and further she has to take care of the parents and for her and herself. Husband has not disclosed the true facts and has not true facts consider about his income. He is having several properties and income that is not disclosed. It is submitted that even as per his own statement, he is having 38,000 salary and also 12,000 towards the rental income. In those circumstances, the court ought to have granted maintenance to the wife. Next para. When counsel appearing for the respondent husband submits that when the MC is filed in the year 2020 till 2023, the wife had not filed any application. At the fag end, when it is at the time of trial,
Right, respondent evidence.
when the matter is posted for the evidence of the respondent husband,
Respondent wife.
respondent wife, at that point of time, she has come up with this petition, and after the court has dismissed, the present petition is filed, and she has sought for stay of all further proceedings in the MC, and in view of the interim order that is granted by a coordinate bench of this court, the entire proceedings are stayed. It is submitted that at present the salary of the wife is 1 lakh. She is more qualified than the husband, and even her salary of 35,000 as stated is in fact is not the correct figure. And according to the husband, she is earning
45 as on date of the application.
45,000 as on the date of application and 1 lakh today. It is submitted that the wife coming up with the application after almost 3 years from the date of the petition shows that she has no necessity and she is able to maintain herself. It is submitted that the court had rightly considered and dismissed the application.
My lords, I had one more submission. She has relied on a lease deed, my lords, which is already expired. She doesn't even live in that address. However, that only to show an expenditure of the rent, that lease deed has been filed. I have raised an objection with respect to that. She is in self-acquired property also.
Not all not required.
Please.
Heard the land counsel for the petitioner. Heard the land counsel on either side. Corrects the material on record. Both the wife and husband are educated, and one earning one wife's salary is 35,000, husband's salary is 38,000 as per the admitted by the parties, by the wife, as stated by the wife and as stated by the husband. According to the wife, she has some more commitments, and that is not, husband is having more, having the properties and income which is not disclosed. And according to the wife also, according to the husband also, it is the same grievance. The whole purpose of section 24 of the filing an application, section 24 of the Family Courts Act is, Hindu Marriage Act, is to take care of the needs of the wife in the interregnum period. In this case, admittedly, she has filed the application after 3 years, even not looking at that aspect. Otherwise, when the wife who is earning substantially on the ground that the husband is having other income, cannot be a ground for the court to grant the maintenance. Considering the educational qualification of both the parties and considering the income of both the parties, the trial court the family court had rightly considered and rightly rejected the petition, and this court finds no reasons to interfere. Dismissed.
Grateful, my lords. My lords, a timeline may be kindly fixed for the
MCs of the year 2020.
2020.
This is an MC of the year 2020, and by December 15, the so-and-so court shall dismiss. Principal court.
Principal court. My lords, 6th additional.
The 6th additional family court. So it's 2020. I think it's 6th additional 2020. No direction can be given. It's only till 2019.
My lords,
if it is principal family.
Principal.
My lord, it is in 5th additional family.
5th additional. No.
5th additional.
5th additional is only till 2019. It will be done in the next year.
Yes. My lords, at least 6 months or expeditiously if it is recorded. Please, lords.
Yes.
Much obliged.
No expeditious. Yes. Done.
My lord, can one finally be given? This should not bear on the final paper.
These are all the observations.
Because
the observations made by this court or for the consideration of the interlocutory application, and these should not be construed as an expression of the court, and the court shall consider the issue on the merits of it.
Much R&S. Judicial or R&S, anybody it will do. My lord, reached to 5. Over.
List 5 hours.
What happened? What do you want? 2.1 serial number. Respond number 1 ಗೆ notice dispensation ಮಾಡಬೇಕು.
You want notice to be dispensed with. Take it. A memo is filed seeking dispensation of notice to R1. R1 memo is taken on record and dispensed with. I have ordered notice before lunch. Look at it.
There is delay of 229.
No, 229. Claimant's appeal.
Yes, ma'am. Yes, ma'am.
Look at it. Is it claimant's appeal?
Yes,
She's
it is
not saying.
claimant's appeal and one more is that insurance company because Umesh is appearing.
So how many days delay?
There is 229 days delay.
Same. IA number so and so to condone the delay. Delay condoned on condition that they are not entitled for interest. It is.
ಇವಾಗ ಇದನ್ನೇನು ತರ್ಸ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಇವ್ರಿಗೆ ಕೊಡ್ಬೇಕಾಗ್ತದೆ ನಾವು.
ಅಲ್ಲ ನೀವು ನಿಮ್ ಕಾರ್ಡ್ ಆಗಿರೋದು ಅವ್ರಿಗೆ ಪೇಸ್ಟ್ ಮಾಡಿ ಮೇಘಾಗೆ. ಅದೇ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅದೇ R1 ಗೆ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ನೋಟಿಸ್ ಮೆಮೊ ಫೈಲ್ಡ್ R1 ಡಿಸ್ಪೆನ್ಸ್ ಡಿಲೇ ಕಂಡೋನ್ಡ್ ಗೊತ್ತಾಯ್ತಾ? ಮೆಮೊ ಫೈಲ್ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಫಾರ್ R1 ಅಲ್ವಾ? R1 ಡಿಸ್ಪೆನ್ಸ್ ಡಿಲೇ ಕಂಡೋನ್ಡ್ ಅಷ್ಟೇ. ಅಯ್ಯೇ ಅಲೋಡು ನಂಬರ್
ಲಿಸ್ಟ್ 5 ಕೊಟ್ಟಿಲ್ವ ನನಗೆ ಲಿಸ್ಟ್ 5
ಇಲ್ಲಿ ಬಿಡಿ ನಾನು ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡ್ತೀನಿ ಫೋನಲ್ಲಿ.
ಹೌದಾ?
ನಾನು ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ ಬೇರೆ ಏನು ಆರ್ಡರ್ ಆಗಿದೆ ನಾನು ಟೈಪ್ ಮಾಡ್ತೀನಿ.
ಅದನ್ನ ಬೇಗ ಕಳಿಸಿ. ಎಷ್ಟನೇ ಸೀರಿಯಲ್ ನಂಬರ್? ಲಿಸ್ಟ್ 5 List 1 serial number 5
So that's fine. You send that copy to me only. I will send Sadananda. You give that copy to him. Impugned order copy. Impugned order copy. Passed by that family court judge. No, that one. You give now. Shall I send?
ಮೇಡಮ್ ಇದು ಫೈಲ್ ಬೇಕಲ್ಲ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮುಗಿಸ್ತಿತ್ತು ಮಾಡಿ.
ಅದು ಮೇಘಾ ಫೈಲು ಅದು ಸದಾನಂದನ ಹತ್ರ ತರ್ಸ್ಕೊಂಬಿಡಿ. ಅವ್ನು ನೋಡ್ತಾನೆ ಇವಾಗ ಏನಾಗಿದೆ ಅದ್ರಲ್ಲಿ ಇದೊಂದು ಡಿಸ್ಮಿಸ್ ಇದು
ಬರಲ್ಲ ವಿತ್ಡ್ರಾಲ್ ಬರಲ್ಲ
ತೊಳಿ ಅಲ್ಲಲ್ಲ ಡಿಸ್ಮಿಸ್ಡ್ ಡಿಸ್ಮಿಸ್ಡ್ ಆಸ್ ವಿತ್ಡ್ರಾನೆ ಅವೆವ ಸ್ಟೇ ಏನಂತ ಬೇರೆ ಗ್ರೌಂಡ್ಸ್ ಹೇಳಿದ್ರು ಕನ್ವೆನ್ಷನ್ಸ್ ಹೇಳಿದ್ರು ವೈ ಇಟ್ ಇಸ್ ವಿತ್ಡ್ರಾನ್ ಅಂತ